Good morning, everyone. Today is Thursday, April 9th, 2026. This is an agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben. I'll take the role of the other commissioners who are here for today's hearing. Commissioner Partridge.
Here.
Commissioner Hahn.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
Here.
A quorum is present. We have 7 items on our agenda today. We are going to finish the first 6 by noon, take a half-hour break, and then take up the last agenda item at 12:30. That is the hope. And I'm saying that to my colleagues most directly. That is the hope, so that then Commissioner Sullivan has other business that he has to do in the afternoon, so we're trying to get done as much as we can before he needs to step away for that. So we will begin with item number 1. Ms. Ricker, please introduce the first docket for us.
Good morning, Commissioners. Item number 1 is docket number E015/AI-17-568 in the matter of Minnesota Power's petition for approval of the EnergyForward resource package. The issue before the Commission is, should the Commission rescind the approvals of Minnesota Power's NTEC-related affiliated interest agreements? The only item that was filed after briefing papers was a set of preferred decision options from Commissioner Sieben, including Sieben New 4. Commissioners should all have hard copies. I have extra if you need that, and there are copies of that filing at the side table in here. I'm available for questions, but have no further comments.
Thank you, Ms. Ricker. We'll begin with introductions of the department and the company. So when you're ready, Mr. Brodeen, please state your appearance for the record.
Thank you, Chair Sieben. Matt Brodeen on behalf of Minnesota Power.
Good morning, Chair Sieben and Commissioners. Sydney Lieb with the Minnesota Department of Commerce.
My first question is for both the parties to see if you had an opportunity to review my new decision option and if you have any comments on it or supportive of it. Mr. Brodeen.
Thank you, Chair Sieben. Yes, we've had a chance to take a look at that and review them. We agree with both your 1C and Sieben New 4, and don't really have any proposed changes to those.
Okay, thank you. And Dr. Lieb.
Chair Sieben, the department has reviewed the chair's decision options. We have no comments and we're supportive.
You're supportive of 4, Sieben New 4?
Yes, we are. Great.
Mr. Brodeen, it was reported in the press that Basin has withdrawn its ownership share in NTEC, and I didn't know that until that was called to my attention. So is there any update that the Commission, how we should think about that, or what other factors to consider with regard to the Basin pulling out, that maybe some of it will be addressed in the new decision option, but anything to add?
Chair Sieben, I don't think that it affects this docket as much with the affiliated interest agreements. We'll certainly provide updates on the project in if Sieben New 4 is adopted in the updated filing. The parties, the remaining owners right now, are working to determine the future of this, including Minnesota Power's involvement as the agent and the guarantee. So that's being worked on by the current owners right now, and then charting the future, as you mentioned, without Basin or NRG, which was their subsidiary in Wisconsin.
Okay, thank you. Commissioners, questions? Anyone? Then I'll move my decision options, which are 1C and Sieben New 4. Any discussion of my motion? All in favor, please say aye.
Aye.
Opposed? The motion prevails. Thank you very much. Good morning, Mr. Lee. When you're ready, please introduce our second item.
Good morning, Chair Sieben and Commissioners. Item number 2 is docket number E017M25338 in the matter of Otter Power Company's petition for approval of the Distributed Solar Energy Standard projects. The question before the Commission is, should the Commission approve Otter Power Company's investments in the Distributed Solar Energy Standard projects? Staff filed revised decision options, which clarifies decision option 4. Commissioners have received the revised decision option list, and printed copies are available at the front of the room. There will not be opening remarks, and I have no further statements, but am open to questions. Thank you.
Okay, thank you. Could we begin with appearances by the parties? Ottertail, looks like you're online. Good morning. Hi, Mr. Jensen, please. You're really loud online. You don't know that, but please state your name for the record.
Good morning, Chair Sieben. Nate Jensen with Otter Power. Do I need to talk quieter?
It's not your fault, but it sounds like it's very loud. And Dr. Lieb.
Good morning again, Chair Sieben, Commissioners. Sydney Lieb with the Minnesota Department of Commerce.
Okay, we'll turn to Commissioner questions. Who would like to begin? Commissioner Partridge.
Thank you, Chair Sieben. My question is for the department and the company, just to clarify that you are both in agreement with the time frame in the revised decision option 4. And I'll start with Dr. Lieb.
Chair Sieben, Commissioner Partridge, we worked with the company, and I believe we are in agreement.
Thank you. And Mr. Jensen, you can whisper your answer.
Chair Sieben, Commissioner Partridge, that is correct. We are okay with that time frame.
Excellent. And then I think I have one more question before we, did my mic go out? Sorry. I have one more question before we move forward, and that was just to the company, if you could give us an update on both your intention to seek tax credits for both of these solar projects and your understanding of how tax credits as they currently stand will impact the projects.
Mr. Jensen or Mr.
Chair Sieben, Commissioner Partridge, it appears that Mr. Stephenson was able to join us, and I am going to pass this one to him.
Mr. Stephenson, you're on mute, but please state your appearance for the record and then whisper everything too, please.
Good morning, Chair Sieben and Commissioners. Kerry Stephenson on behalf of Otter Power Company, and apologies, I was having technical difficulties getting signed in this morning. With regard to the tax credits, we assessed and continue to assess that we will be eligible for Section 45Y production tax credits for these projects. That was our judgment when we filed this petition, and it remains our judgment right now. And we had asked for expedited treatment, really just to be very, very cautious. There were a lot of things changing when we made the filing. There had been new tax guidance or Treasury Department guidance under the the BBB, and we wanted to make sure that we had optionality if something unanticipated happened. But we fully anticipate that these projects will be eligible for 10 years of Section 45Y tax credits.
Commissioner Partridge.
Thank you. That was very helpful. I don't have any additional questions, and I am prepared to make a motion whenever everybody's ready.
Sounds good.
Okay, excellent. So I'm working off of our revised decision options filed on April 9th. And my motion is decision option 1, decision option 2, decision option 3, decision option 4 as revised, all parts, and decision option 5, all parts.
Great. Is there any discussion of Commissioner Partridge's motion? Hearing none, all in favor, please say aye.
Aye.
Opposed? The motion prevails. Thank you.
Thank you.
The parties can come forward for item 3 too, if they are here in person. Mr. Warbler, good morning. Please introduce item number 3.
Good morning, Chair Steven and Commissioners. Item number 3 is docket number E002/M-25-400 in the matter of Xcel Energy's petition for approval of its 2026 renewable energy standard rider revenue requirements. The question before the Commission is, should the Commission approve Xcel Energy's petition for approval of its 2026 renewable energy standard rider revenue requirements? The parties are available and staff is available.
Thank you. We'll begin with appearances. Mr. Dobson.
Thank you, Madam Chair. Commissioners, Ian Dobson with Xcel Energy.
Ms. Campbell, good morning.
Good morning. Nancy Campbell with the department, and online I have Lynn Bear, also with the department virtually.
Great, thank you. We'll begin with Commissioner questions. Commissioner Sullivan.
Thank you, Chair Sieben. A question for the company and the department. I'm just thinking about the renewable energy rider, and if you could speak to how this project, the Sherco BESS, is directly related to our renewable energy facility. I just want to kind of lock this in for the purposes of the res rider recovery.
Understood. Thank you, Madam Chair, Commissioner Sullivan. And to the extent that you want to get into technical engineering, we have someone online that can do that. But hopefully I can give you enough here. The way we see this as directly related is this battery, along with Sherco South battery, and all of the renewables are going to be coming together at one sort of the same substation. So Sherco Solar 1, Sherco Solar 2, Sherco Solar 3, MNEC, all of those are going to come in at the same substation. And then out of that substation, we will be able to put this onto the grid. What the battery does for these projects, these renewable projects, is allows us to effectively produce more energy than we would otherwise be able to put onto the grid through that interconnection, and the battery sort of acts like a sink, absorbing some of that energy that we otherwise may have to curtail because we're limited by the interconnection.
Energy directly attributable to the solar array there.
Correct. The solar array, Sherco 1 is obviously most closely in physical proximity, but it would basically improve our ability to operate that renewable resource, Sherco Solar, because we would be able to basically absorb that energy to release later when our interconnection would otherwise prevent us from doing so.
That's helpful. I suppose to the department, do you have anything additional?
No, I think that's our understanding, that it would help with the solar, hang on to some of that energy overnight and use it to shave off the peak. So it seemed like it was very tied to the solar.
Okay. Another question I had, Mr. Jobson, is do you see an increase in accreditation, the MISO accreditation for the facility? Because if there is an increase in accreditation, that would directly be tied to the performance of the renewable.
Madam Chair, Commissioner Sullivan, I frankly, I don't know if a specific solar or wind facility would be accredited differently in MISO. I think the way we see it is we're going to be able to sort of stream, like more, be able to push more throughput through that interconnection, over time.
That would be reflected in the accreditation. That would.
Yeah,
I
understand what you're saying. Yeah.
Yeah, along that lines, Madam Chair. JD, go to your slide. Just cut to the chase. I want to get this understood. And I think what was difficult, I think we have to distinguish from Blue Lake. And Blue Lake is, we're building a battery, and it's going to help all these different renewables that are around there be better. Okay, and we said no to Blue Lake. We said yes to South, and now we have West. And I think a concern is the directly related when you have a battery that also can draw from the grid. And so that starts to look a little bit more like Blue Lake, okay? And this is what I think you were explaining to Commissioner Sullivan.
Is this, sorry to interrupt Commissioner Tuma, but what we're looking at, is this in the record?
Yes,
Okay, in the company's filing?
yes.
We don't know where, or it's figure 1.1 in the company's
It's on page
original
3 of the
petition.
executive summary of their
Okay.
chapter 1 of their filing.
Perfect.
And I think this is what helped me understand it better. And I think when you have a grid drawing battery, we have to do a little bit more examination, a little more careful examination of the facts of the facility to make sure that it's directly related. The standard one is where you have a solar facility and a battery tied to each other that are feeding each other and then go to a meter and then go out one direction, okay? That's an easy one.
Yep.
When you get the bidirectional one, that gets to be where we need to make a little bit more of an understanding. And so the way I understand Sherco West and also Sherco South, I believe operates the same way, but you can tell me if I'm wrong, is that 1 and future 3 go to a solar substation, okay, which my question is my guess is that then can feed directly the battery, doesn't have to go out into the grid, okay, and they can share energy. So they're being built at the same time, sized at the same time, and built on the same series of substations that will eventually go to the Sherburne substation, where the grid is. And so, to me, that puts it clearly as something that is directly related, even though incidentally it could draw from the grid to make it more economically viable. Overall, there is a connection here. I don't know if that's the line. I think there could be other projects that would still qualify that maybe even out on the grid. But for now, when we're drawing this line and getting to where Commissioner Sullivan wants to get, when I saw this schematic of how it's put together and how it's interacting with each other, that seems like you're working together, sizing these things together so that you can get the best economies of scale from both of them. And because of their size, drawing from the grid back through these substations makes sense. Is that fair? This is the attorneys talking. That's why I wanted to make sure you got your engineers here.
I will, Madam Chair, Commissioner Tuma. I love that you commented this is the attorneys talking, because the number of times I've had to sort of have that attorney to engineer discussion. I think yes, that's how I think you're thinking about that right. I agree with how you're thinking about that. I think what I would add to get to your point about Blue Lake, and maybe this is sort of the overarching piece, Blue Lake was a standalone battery. It was only charging from the grid. And, obviously the argument we made in that case that the commission rejected was because it is charging from the grid, it's helping all of these renewables. This is different in that the purpose of it being located here at Sherco, it can charge from the grid. It has that added benefit. We will use it in that way. But the purpose, the benefit of it being located here at Sherco is that it provides this added benefit to, the Sherco Solar and, as you see in this schematic, the Sherco Solar 1 and 3 sites. So it is adding to those projects' economics. And then it will add to the economics of the projects on the MNEC as well. Those are renewable projects. But that distinguishes this project from how we see, Blue Lake or some other standalone battery that is simply connected to the grid.
And I think there needs to be, and I think Commissioner Sullivan is absolutely right to ask these questions. I think it's a very fact-based discussion about whether it is directly related. I mean, if you just hung out a single solar panel on the fence of Blue Lake substation and say, we're going to count that one solar panel and connect it to this battery, that's not going to qualify. There needs to be some size relationship, and I think some understanding that the dominant feature is the renewable energy project that qualifies. Would you agree with that?
Madam Chair, Commissioner Tooma, yes, I think that makes sense to me as I'm understanding it. That's why this is, that's a huge benefit of why it's being located here.
And those are factual questions that we'll deal with in the future. I just wanted to make sure, as people are bringing forward projects in the future, because batteries are not unusual now. We're dealing with lots of batteries, and so there's no longer that learning clause under 1645. It's now they're going to be there. Now the question is, are they bringing benefit to the renewable energy project? And I think that's where you were going, Commissioner Sullivan, and I agree with you wholeheartedly. This qualifies, but in the future, when you bring projects, other utilities bring projects, this one is in, you have to do a very factual, close analysis to make sure there is a direct connection to that renewable project that qualifies. So
understood.
Any other questions for the parties?
I'm ready to go with a motion. I was going to just say, I recognize that there's I feel like the conversation has clarified for me that this qualifies for the res rider, so I'm comfortable with decision option 1. As far as the bypass, the $3.2 million in cost for the bypass, I think that's more appropriate for the rate case and for the review in the rate case. So I'm going to exclude that from my motion. So I would move decision options 1 and 2. So 2 excludes the $3.2 million in costs exceeding the cap for Sherco 1 and 2. And decision option 1 approves the cost for the res rider.
along that lines, Commissioner Sullivan, that raises a question. I'm glad you went there. I forgot about that. I was so focused on the substations. The 3.2 is an actual, when you say that, that's not a cap violation. That means, in your mind, it wasn't qualified. And therefore, in my mind, that means we don't need to wait for the rate case. They should almost do a compliance filing and change the res rider. The cap violation is, yeah, you qualify. We just got to figure out how much is over the cap versus we don't think you qualify. So I'm thinking there's a concern here, and I apologize. It's one thing when you say it's a cap violation.
But Commissioner Tuma, we'll let the parties respond to what you just said, but you're saying you don't support number 2?
No, I do. I do support it.
But you support it for a different reason?
Well, I think it's the same reason, because he just said 3.2 doesn't qualify.
Well, that means whether
Which
it's
is
going
different
into the
than-
res.
Then it should never have been in the res rider, and they should adjust the res rider versus the cap violation that it does apply, and we need to just figure out whether it was prudent and reasonable.
You got my head twisted up.
Yeah,
with that
I think
pretzel.
we're,
I think that maybe Ms. Campbell can.
wait, let's just,
Sorry.
hold on a second. Commissioner Sullivan proposed decision options 1 and 2. And Commissioner Sullivan, Commissioner Tuma now is raising concerns about excluding the 3.2 million from the cap, correct, Commissioner Tuma?
I'll try to explain it again. I'll work with Ms. Campbell to make it clear, okay? So Ms. Campbell, when I look at this, okay, I was given essentially a look at this. If it's a cap violation, so in other words, it does qualify. In other words, you can make an argument that a Sherco coal plant causing condensation on lines needing to cause $3.2 million in expense, okay, is not a res rider covered item. And therefore, it's not a cap violation there. It's just, it's not in the res rider. Versus condensation from a coal plant getting onto lines that are causing the res rider applicable solar facility not to produce as much, okay, is actually still res rider activity, okay, and that res rider activity, because it costs $3.2 million, exceeds the cap by $3.1 million, okay, and therefore is a question of whether that was reasonable and prudent, or other activities were reasonable and prudent, or something we would deal with in the rate case, because it is recoverable, but it's over the cap, and that's a rate case matter, okay, versus no, coal plants condensing on those lines is not a res rider issue, and therefore should just be excluded, and you should redo the res rider, and we don't even have to go to the rate case. Am I making sense, and can you explain it a little bit better to me?
Ms. Campbell, and then answer Commissioner Tuma's question, and then please summarize why you were supporting decision option 2, independently of what Commissioner Tuma just said.
Certainly. Nancy Campbell for the department. Let me take a crack at that. We really thought it was a cost overrun issue, but I think regardless, it doesn't matter. We get to the same spot. The number is 3.2 million. The company clarified that it wasn't 3.1, that it was 3.2. And regardless, it doesn't get recovered in the rider, whether it's a cap overrun or whether it's not qualified. We don't even have to fight about that. I thought it was a cap overrun. And the 3.2 million can go to their next rate case where the company will have an opportunity to make their case.
But you could still make an argument then at that stage that, no, it's not res rider applicable. Coal stations causing condensation shouldn't be covered.
We're now in the rate case, so I really don't think that really is an issue. So they really just have to make their case that the 3.2 million was appropriate.
Yes.
We'll see them.
And that was a confusion I had, because I thought they still disputed you in the last filing I was reading, that they still disputed you over the 3.1 versus the 3.2. But you're saying we're okay, and it's such a small amount. As long as we reserve our arguments on both avenues, it's fine.
That's correct. My understanding is they agree with, Xcel agrees with us, but you can confirm that they also agree that they will take it out of the res rider and do a recalculation and a compliance filing. So I think we're fine.
Mr. Dobson.
Thank you, Madam Chair, Commissioner Tuma. I'll save the complexity, but I agree with what Ms. Campbell said. We would, based on the decision option, we would take the 3.2 million out, we'll make a compliance filing, and then we can move to the rate case where we would make whatever arguments we make.
Sorry for spinning your head around.
No, that's okay. Can we go back to the complexity?
Madam Chair, Commissioner Sullivan.
I know, I'm kidding. I will remake my motion for decision options 1 and 2. I think that clarity is good, so I'm happy. So that's my motion to decision options 1 and 2. Happy.
Any discussion of Commissioner Sullivan's motion? All in favor, please say aye.
Aye.
Aye. Opposed, the motion prevails. Thank you.
No.
The parties can come forward for the next item. Actually, there aren't this is a recon, so never mind. Staff can come forward to introduce it. Mr. Davis, I don't know if we've had you introduce an item before, so welcome to introducing this item, which is number 4.
Thank you, Chair Sieben, Commissioners. Good morning. Agenda item number 4 is in reference to docket number IP-701-WS-19-619 in the matter of the application of Big Bend Wind LLC for a large wind energy conversion system site permit for the up to 300 megawatt Big Bend Wind project in Cottonwood and Watonwan counties, Minnesota. The issue before the commission is, should the commission reconsider the decision to approve the site permit amendment for the Big Bend Wind project? Staff has no additional comments, but I'm available for questions.
Thank you, Mr. Davis. This is a petition for reconsideration, and I'm not intending to take comments on the petition. Are there any questions from commissioners for the parties? Hearing none. Commissioner Sullivan, do you have a motion?
I do have a motion. I've reviewed the briefing paper and the records, and, you know, in my view, the reconsideration petition doesn't raise to the threshold that's necessary to reconsider. So I will move decision option 2 to deny Mr. Hutchinson's petition for reconsideration. Happy to answer any questions.
Madam Chair.
Commissioner Tuma.
I support that. I did note that there was some discussion about bald eagles, which wasn't in original discussions filed by the applicant of the motion. And I just wanted to double check. As you know, I have a great deal of concern about those issues and wanted to make sure that our original permit did have directly address, thank you, the concerns around the bald eagles and other wildlife stuff. And I saw nothing in the record that changed my opinion or that is new or needs to be addressed.
So just to be clear, when you reviewed the order, you found that there were mitigative steps taken.
In the original permit in the decisions that we made, yep.
That was adopted in our order.
That's
and
correct.
So that is consistent with a reason to deny the petition for recon.
Sure, thank you.
Any other discussion? All those in favor of Commissioner Sullivan's motion, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you. Okay, then when staff is ready and the parties will move to agenda item 5. Mr. Harville, please introduce item 5.
Good morning, Chair Sieben and Commissioners. Item number 5 is docket number CN 25109 involving Minnesota Power, Great River Energy, and Otter Power Company in the matter of their application for a certificate of need for the Maple River to Cuyuna 345 kV transmission line project. The questions before the Commission are, should the Commission accept the certificate of need as application is substantially complete? Should the Commission authorize review of the certificate of need application using the informal process or refer the matter to the Court of Administrative Hearings for contested case proceedings? Should the Commission consider any additional procedural items? Staff has the following opening remarks. Commissioner Tuma filed the new decision option on Friday, April 3rd. The new decision option requires the applicants to supplement the certificate of need record with a discussion of specific additional alternatives and segment alternatives and to request and pursue coordination activities with the Minnesota Department of Transportation with the purpose of obtaining a constructability report for the previously mentioned alternatives or segment alternatives pursuant to Minnesota Statute 161.45, Subdivision 6. Physical copies of this decision option are available in the back. Staff has no further remarks and is available for questions.
Thank you, Mr. Harvo. We'll begin first with, well, should we begin with, do you want to go straight to questions?
Yeah, I mean,
Commissioner Tuma, I
get it wrapped up pretty quick.
I do want to since you filed late decision options and we haven't heard from the applicant about the late decision options that were filed, why don't we start first with the applicant and please provide any comments on the overall decision options, please.
Thank you, Chair Sieben. Cody Verhalen with the law firm of Taft, Titanius, and Hollister on behalf of the applicants Minnesota Power, Great River Energy, and Otter Tail Power Company. The applicants support staff decision options 1, 4, 5, 7, and 9. The applicants respectfully request that any decisions related to routing of the project, including Commissioner Tuma's proposed new 10, not be adopted at this time. The applicants want to emphasize that it really is a routing decision and not a completeness determination that the PUC needs to make at this time.
Okay, thank you. And then Commissioner Tuma.
Now, this is a walkthrough, and I want to just make sure I track with kind of where things are with the decision options. It's my understanding, because you're following existing right-of-way, at least that's the indication in the CN, that we will probably have 80% in the, I would say, paralleling or next to right-of-ways, so that qualifies you for the standard review under 216I.07 as opposed to the major review, which would normally be for 345 kV. And so I guess my question to you, looking at the schedule that was in the briefing papers right away, and it was also in your filing that you had for this kind of a schedule, I think it's helpful for our staff to know how this is playing out. We have done auto tap. We have had an experiment with 216I standard review. It went well. Okay. This is the first major kind of project that may be working its way towards a standard review. And so my question to you, is that still your plan to seek standard review? That seemed to be what you were indicating in the CN, but just for our staff so we can be all clear, is that your desire to get this under standard review with the co-location 80%?
Chair Sieben, thank you. Chair Sieben, Commissioner Tuma, one point of clarification, the ISA project, the Iron Range St. Louis County Arrowhead project, was also submitted under the standard review process, and that one is going through the Commission's process. We had scoping meetings earlier this week and this evening. At this point in time, the applicants can't definitively say which process is going to be used for Maple River to Cuyuna. There were public open houses held 2 weeks ago to get additional public feedback related to the route permit development. From a known infrastructure in the area, looking at the notice plan, yes, there are opportunities to follow existing high voltage transmission lines, and if that threshold of 80% can be reached, then a standard review process would be sought consistent with 216I.
But and August is what you said in the CN in the schedule that you give. Is that still generally kind of what you're thinking? Again, not holding you to it, but I'm just trying to look at this as we plan ahead so that we have a good understanding of how this is going to play out in comparison to other major projects that we're going to deal with.
You're asking Commissioner Tuma about when they're going to file the route permit? Yes. It's August, right?
Chair Sieben, Commissioner Tuma, that is still the intent of the applicants. There's nothing that has changed that proposed timeline.
Good. Now I want to look at just the decision options. You said 1, 4, 5, and 7. We have a docket coming later where it's going to actually be 1, 3, and 7. Okay, and I'm trying to understand the value of making a referral of the CN if we're going to marry them. So my understanding is it's still your desire, is it not, to essentially stay this proceeding, the CN proceeding, and work them together. And that's traditionally 1, 3, and 7. Okay, so I'm a little bit confused why we would be making a kind of predetermination to do an informal process review of the CN when we're going to have a kind of an analysis and a decision in August or soon thereafter on the joint process. And so that, to me, the right motion would be 1, 3, and 7. It's not saying I think it should be any delayed. I'm not looking for delay, but I think this is what tease it up because we don't know what you're going to bring to us with the permit. It could change the decision about what we use for a process. So I don't know why we would make that decision now when we're actually staying under number 7. So help me out. Why would you want 4 and 5 at this stage?
Ms. Verhalen.
Chair Sieben, Commissioner Tuma, as you said, this matter will come before the commission again. So any referral would really be an initial referral by the commission based on what it knows at this time on the certificate of need. If when the route permit comes forward, there's additional information that a different decision needs to be made, there wouldn't be any action between now and then at this point in time. And so the commission could make a different decision at that time. 1, 4, 5, 7, and 9 seemed the most efficient at this point in time for purposes of where this project sits and what staff has analyzed in their briefing papers.
That's the confusion I have. I don't see the efficiency. I mean, 3 stays it, 7 stays it. It still stayed under 7. So I sending a letter to the ALJ's office or the OAH or whatever we call it nowadays, or CAW, I guess. I don't know what efficiency I'm buying with that. So that's the confusion I'm having. I don't know what that efficiency is. So help me. What is that efficiency that I'm gaining?
Ms. Verhalen.
Chair Sieben, Commissioner Tuma, getting it on the Court of Administrative Hearing schedule at this point in time, letting them know what the proposed schedule is, could aid the court in assigning administrative law judges. As you requested, additional information on timing for the route permit application and that timing, so your staff is aware, aiding the court in understanding what it has upcoming on its docket would be helpful as well. I am assuming, but knowing how many projects there are coming before this commission and how many projects will eventually be going to an administrative law judge from a timing perspective.
It might warm your heart to know that actually with the new law, okay, that we have been having quite a few conversations with CAH, I guess is now what we call them, and they're well aware of the timelines, the standard review versus the major review, and so those conversations have been ongoing, and our staff has, I won't say new lines of communication, I would say enhanced lines of communication with our judges, and they are well aware of the MISO projects. I don't know who's to blame for that, but all the MISO projects that have been flooding our way, and so I'm not as concerned about them knowing about this. So I'm knowing that. Are you comfortable with 3? Trying to be consistent here.
Commissioner Tuma, can I just interject? I think one other factor that I understood from my briefing with staff is that the applicants, because of the timing of when MISO released the full tranche, like they had to file their CN application, as you know, in February or by February. And so today, like I had a lot of similar questions with staff that I just want to interject with Ms. Verhalen and see if my thinking lines up with my conversation with staff, is that the applicants filing the CN, there is still a statutory requirement to complete the CN will be roughly next February, but with the consent of the parties, we can extend the CN timeline. So so my question to Ms. Verhalen is, that would be your intent of waiting, because I understand the route permit isn't ready to be filed. There are efficiencies in running the route permit and the CN together, and I think it's more transparent and clear for the public as well. And if now we can say that we're going to do that informal review process, we, again, as Ms. Verhalen said, are like notifying the court that this is likely the procedural path we intend to take.
There's the court calling us right now.
Yeah.
No.
And then, so like the timing in terms of efficiency should match up still, taking the informal process, but also having, and I think result in more clear procedural outcome for the public if we set this procedural path now. So I'm not exactly sure what you were, why we would defer consideration of the route permit until we get it, when, like, we need the consent of the applicant to extend our time frame for the CN, and then the route permit will still have its own set of timelines as well. So, Ms. Verhalen, that wasn't a great question, but is that your kind of understanding of how it would work, where procedurally we would be marrying up the CN and the route permit, and then the applicants would be requesting an extension of when the CN timeframe would be done? That would likely then match up with the informal consent process and the route permit proceedings.
Chair Steven, that's correct.
Madam Chair, I'm just looking for consistency. Number 7 says, stay review of the certificate of need application until the route permit application is filed. We agree on that. Everybody's agreed on that. So why are we sending something to the Office of Administrative Hearings and then turning around and saying, oh, I don't do anything with this? On the next one, the 765 kV, we are doing 3 and 7. And so I'm just trying to say, consistent. They're the exact same thing. We're staying both. Number 7 is saying, stop, don't do anything. So why would we send it to OAH when we're just saying, stop, don't do anything? So I was just trying to be consistent. So, I mean, we don't have to. I don't want to waste any more time on this. It doesn't matter because 7 overrides everything here. And if we're going to send this one and not the other one, I don't care. I'm just trying to be consistent.
Wait, when you said not the other one, you mean the route permit, or you mean the other docket?
Other docket.
Yeah. But I'm
just taking a look at it. I was asked to look at the decision options. I'm telling you what I'm seeing. I'm just trying to keep it simple and consistent is all I'm trying to do. Not trying to complicate, not trying to throw wrenches in this. I want this to go forward. So don't think I'm trying to do anything magical here. I'm not. I'm just saying it makes more sense to me to stay number 7 and defer number 3 on all of these type of projects, these big projects where we're waiting for them to get married up at the permit for the actual route as opposed to the CN. That's it.
Ms. Verhalen, what's the problem with what, on the timing, or what Commissioner Tuma said and why you're proposing the other alternatives?
Yeah. Chair Steven, Commissioner Tuma, what you are proposing is not a problem. The applicant's goal is to provide that clarity in the process early. If the commission chooses to move 3 and then skip over 5, we'll be back here again with the route permit, as we said, and we can have that conversation at that time.
Which we're going to have anyways.
Correct.
So I don't care which one. My motion is going to be 1, 3, and 7, and 9. We can talk about the other one here in a second, but that I just wanted to get clarity on what we're going to do for the base motion. So.
Again, Commissioner Tuma, so you would say we'd accept the CN as complete. We don't make a decision on
CN process until we decide on route process, which are going to be exactly the same thing.
But why wouldn't we just choose the informal review process now?
We don't have the permit in front of us.
Yeah, but this is
Because
about.
The route could, and she's indicated, the route could be a major process. We don't know yet. And so that's what's going to drive this for his timing and how it's going to move through is going to be the route permit, not the CN permit. You're going to say to us, let's do them together so that it's clear to the public what we're doing. That's what's going to happen when we get to August or soon thereafter.
Ms. Verhalen.
Just really briefly, thank you, Chair Sieben, Commissioner Tuma. What I'm hearing, though, as a difference is the certificate of need, if it is in the notice, comment, reply process, could possibly not be part of a certificate of need process, even if the route permit is part of a certificate of need process. There are different questions that need to be answered in each of those processes. And so that is reading through staff briefing papers, looking through the documents, that would be the difference under the scenario you just gave, which is if it is a major review, the route permit could be processed as a contested case, although the certificate of need would follow with it. But the certificate of need would not be a contested case proceeding, meaning a notice, comment, reply.
Yes, and that's all the discussion I want you to have with our key staff, so that as we stay this, number 7, which we all agree on, we're having that clear discussion because we are doing things under the new 216I, and so we want to make sure we're flowing and working with you carefully so that we're meeting all of our deadlines and think through this. But that's a decision we will know much more about when we get to August, and you pretty much have put together what you're going to be your route permit. And so that's what I'm just saying is, this is, to me, the normal process is 1, 3, and 7, not 4, because it doesn't add anything at this stage. You're still going to have conversations with our staff. I mean, that's all I'm saying, is that we'll figure that out when you get to that route permit, and we'll make a decision whether to bifurcate them somehow or do an informal somehow. I have no problem with informal. I just don't know at this stage what we're going to come up with, and I want to give staff the flexibility as they plan and try to figure out timelines in real life to do that. That's all I'm trying to accomplish. And I don't think you're put in any jeopardy of the project not moving forward by doing 3. So.
Commissioner Sullivan, did you have something, and then, or not? And then Commissioner Partridge had something.
Commissioner Partridge can go first.
Thank you, Chair Sieben. So I will just say in my conversations, I had a couple different briefings on the process, and my understanding is very similar to Commissioner Tuma's, I think, which is that the only thing that would not happen, so stepping back, I think staying the process, in my mind, effectively is also 3. We're just saying, great, we're going to marry these 2 processes up, we'll figure it all out when you come back. And the only thing that doesn't happen if we choose 3 is a letter to the ALJ, which, to Commissioner Tuma's point, wouldn't trigger any action because we've stayed it. So I think in my mind, that's the only thing that we would miss if we don't do 4 and 5, because when they come back, we can decide if we want to do 4, and likely we will for the certificate of need portion if we determine. So I don't know that we're missing anything by moving forward. That was my understanding after briefings, but I certainly could be missing something.
Commissioner Hom.
Thank you, Chair Sieben. I think also we are totally ignoring department in this discussion because they are the big part of this process, and they have to allocate their resource. So I hope that we can hear from department on this issue, which direction is better for them to allocate their resource. And then I have another question to the department on the process issue.
Dr. Lieb.
Chair Sieben, Commissioner Hom, the department supports putting the joint and route CN application together. And from this discussion, I think we're in agreement with Commissioner Tuma that we don't need to make a decision on the process, whether it's the contested case or the simplified non-contested case. We shouldn't make that decision until we have the route permit in front of us, if they're going to be joined and moved together. So we would support.
It's not decision option 4 that you filed in the record, it's decision option 3, Dr. Lieb?
That's correct. I apologize that we did not. I think we took that position in the next docket that's up, and it's been a bit of a process for us to think about how we want to do these and how we want to approach them. And so this was the first one through the wall, and by the time we got to the one that's up after this, we have taken that position. So we would like, I apologize for the lack of clarity here, but we think they should be joined, and we think we should delay a decision on specific procedural route until we have both of them in front of us.
Thank you for that clarification. So I'll make one more thing, a little bit more complicated. Because under this proposal, department may be waived from developing environmental review for the CN, and then commission staff will develop. Is it your understanding that decision option 9 will give that?
Chair Sieben, Commissioner Hom, I'm just going to take a second and review. I believe that that is our understanding of decision option 9, and we would support decision option 9.
Okay, in that case, I think a department typically in the CN either comments or testimony developing your position, you also need to consider several statutory mandated system alternative. And also at times, department is developing system alternative outside this mandated system alternative to the project. Because it's a new process, you used to have an in-house EERA helping you to develop that. Now you have either applicant or commission EIP staff doing it. They need your input on the system alternative to develop the environmental review. Is it your understanding?
Chair Sieben, Commissioner Hom, I believe that's right. The department would do the alternatives analysis as required for the CN, but we would not be doing the environmental review. That would be done by EERA, which is now sitting at the commission.
So in that case, because of this process is a state in terms of CAH process, if department stop working on the CN docket, not developing that system alternative, our process will be delayed as much as you are delaying that, providing that information either during the pre-application process under the standard process for the applicants, or the major review process to the EIP scoping process. Without that information, I think we will have a more delay, right?
Chair Sieben, Commissioner Hom, I think I hear that concern. Chatting with my staff, I think the way we would deal with that is even if the CN is stayed, the CN is still filed, so there's nothing that prevents staff from starting to work on the alternatives analysis. So I think even if it's stayed, it doesn't mean it's like on ice. We'll start working on that so that we don't run into procedural delays regardless of whether or not the CN's moving independently.
Yeah, I understand. I think knowing Dr. Rocco, I don't know whether he's helping now, but he's like a machine. He's working on things. However, also we have another component that is we have to communicate, and that we have to follow the statute to communicate proper way. So that's why I think I was pointing this out. I think probably we have to have some follow-up discussion on this.
Chair Sieben, Commissioner Hom, I think if you want to propose a procedural schedule that allows us to start filing analysis associated with the CN, that's so that your staff can start reviewing that. I think that we'd be open to some sort of proposal like that, but I think we have to do it and file it regardless of whether or not we're going to CAH or we're staying at the commission with the case. So I'm hopeful that we can come up with a procedure that works, that doesn't delay anything, without presupposing which track the CN and route permit would move on.
That's why under the number 3, probably you are not going to file anything. Then we have to find the statutorily allowed channel to communicate with the applicants or our EIP staff. But if we go to the number 4 routes, you may be able to file comments, right? Because we already decide to make it as a comment and reply comment process. So I'm not saying one way or another. We have a way to do it, but I think that is a potential consequence of picking and choosing number 3 and number 4. That's why I'm just pointing it out. Also, we have to have a more generic discussion with overall process, because we don't want to have any issue with a specific process on this specific docket. So hopefully we have a more generic discussion about how we can improve this process without having issue with the transparency of the process.
And Commissioner Hom, to address that, Ms. Lee, the question I would have for you on number 9 was going to be this. State is not dismissed, okay? There's still an open docket. And our staff recognizes the need, okay, especially our EIP staff, recognizes the need that they have to work with you to fill out the appropriate environmental review. And they are going to be working behind the scenes. Stay doesn't mean our staff stops, okay? And before, I think that some people believed that in the prior dockets where we stayed something, people just stopped doing things. The goal is, from our staff, is to be working behind the scenes to develop an internal schedule to move forward. And they need your help. They need the Dr. Rocco and his team and the folks there to be able to complete the appropriate environmental assessment. That is going to be happening from here on and through the summer, spring, into the fall, whenever we get the application. You agree with that assessment, and you're willing to continue to work with us as they figure out the internal schedules to make sure we get this stuff done on a time.
Chair Sieben, Commissioner Tuma, I think that's exactly the position I was trying to communicate, which is that we understand state is not, like, it doesn't mean it's closed. It just means we're not making a decision on the procedural path for the analysis at this time. But it doesn't mean my staff won't begin working on it. So I think we can continue to work on the alternatives analysis and anything else that's required for the CN. We can file it in whatever procedural way your staff and our staff, there's probably a lawyer involved somewhere, feels it is acceptable. And I don't think that that means that we have to make a decision on the procedural path for the CN. I think it's cleanest and most transparent if you're going to marry the route permit and the CN that you make a determination on procedural path for those things all at once. But it doesn't mean that we need to stop working on the CN or that we can't file anything related to the CN.
Commissioner Hom.
Thank you, Chair Sieben. Yeah, that's why I say I don't take a position one way or another, but my suggestion is public has to have a transparent understanding of that process. And when information is being shared with the commission staff, you have to do it through the e-filing system. You can discuss that with the applicant since you don't have ex parte communication. But as soon as you want to talk with the commission staff, it has to be e-filed one way or another. Way we make a decision on 3 or 4, doesn't matter. We have that in the transparent way so public can access that information.
Ms. Overland, please state your name for the record.
Carol Overland, representing the Andersons. My question here in this discussion is that this is all on the down low between you all. And, where does the public come in? And especially with system alternatives, and, again, in the next docket, that's more of an issue, but where does the public have its input into system alternatives if all this is being developed between all of you?
Ms. Overland, I think you were in the record. It said that you wanted the commission to decide the procedural path now and send it, the CN, to the CAH for full contested case. Is that right?
That is true, but,
Great.
But with the stay, but for a contested case. And then if that is not done, I would urge number 5, except instead of a summary, a recommendation.
On the overall consideration of a CN.
On the CN, right.
Okay,
But a
and
contested case would certainly be the preferable.
I understand, but on this procedural process issue that I heard a little bit of suggestion that we weren't being transparent, I think that this discussion here is attempting to figure out what is the best procedural path. So not only the department can fully participate in the CN proceedings, but so that it's clear to the public too as well. So I don't know if you agree with that, or I don't know if it matters if you agree with that, but I just want to reflect that Commissioner Tuma's discussion and the discussion amongst commissioners is attempting to figure out a new process that is because of the new statute, but we are operating again under existing law with the CN. And So like what information is filed into the record and when we do very much care about that, so that my overall concern is at the end, the public understands the process we're going to embark on for this project. And that's why in my discussion, it made sense to just say now, you know, we're accepting the CN as complete because of the timeline and the efficiency of wanting to marry up the CN and the route permit. It makes sense to like indicate we're doing that now and that we're going to use informal review. But I hear what Commissioner Tuma is saying, that we don't need to decide that procedural process now, and we will still move forward with transparent hearings and opportunities for the public to weigh in. Commissioner Hom.
Thank you, Chair Sieben. Ms. Oberland, so many years we worked together on these many issues, so I understand your concerns. So I try to address your concern here. Department doesn't have any ex parte communication limitation like us. So you can clearly, as a public or any public, can communicate with the department in their developing their system alternative. So I think that's why I am discussing this in open forum, to make sure that public can hear and then they can have input to department process, unless you have a time, money, and technical ability to develop your own system alternative. We are welcoming it. But we had so many discussions on this issue. Public doesn't have that resource. That's why I think you have to work with the department, make sure that they are advocating on your behalf. So that's why I was making this point to the department, even though we stay, that process has to go on.
Thank you, and I appreciate that. It needs to be a two-way, and I was concerned that here it sounded like a one-way. Make it transparent what they're doing, but we also need to have that opportunity for input.
Either route we will, but thanks for that. It's helpful. I just wanted to ask Cuyuna, who approached the table. Mr. Pranis, please state your name, and because Cuyuna has been filed comments here and has been involved in the process of citing decision lines or transmission lines and determining CNs, I imagine that you're fine with whatever procedural path we take, but wanted to give you a chance to weigh in since you also approached the table.
Thank you, Chair Sieben, Commissioners. Kevin Pranis on behalf of Cuyuna, Minnesota, North Dakota. That's correct. I mean, having listened to the discussion, appreciate the focus on trying to have a clear and consistent path forward that's efficient. We think that's important, but don't disagree that it, at least as we understand it, what we want to accomplish is possible under either of those paths. And so we don't have a preference here. We think it's an important project and look forward to it getting to the sort of comment and review. But obviously, I think we would agree that a route, that the CN consideration of CN is separate from route, and the questions about co-location with transportation corridors to us would be a different question. But I think for purposes of the CN, whether we go forward today with an informal process or wait, we don't have a preference on that.
And Madam Chair.
Commissioner Tuma.
Just to wrap this up, Ms. Raylan, we're going to proceed, but I think it's very clear that when we get to the environmental review stuff, there's going to be a very robust discussion before we finalize the environmental review, and there'll be opportunity for the public to engage in our process. They can engage now, as Commissioner Hom said, but we're not going to cut that short. That's still going to be a very thorough process, and we're going to have a review of and determination of whether the environmental review is sufficient, and you'll be taking in lots of information over public hearings after you get your route permit in, both on CN alternatives and also on actual route alternatives. That's my understanding. Is that yours?
Chair Sieben, Commissioner Tuma, yes, the applicants look forward to what has traditionally been a very robust process for the certificate of need and the route permit application.
And I'm not going to move my 10, okay, but it's out there for a reason, okay? And I think it's something that it's helpful, I think, for you to see what I'm seeing. and understand that we have a new statute to deal with. I don't know how that statute's going to work. I have no clue. But the sooner we have a conversation about what I see as an obvious alternative route, okay, not CN question, alternative route that you can deal with on 10 seems to me to be obvious. I'm excited about the alternatives that you are talked about in the CN, the different directions that you're looking at for co-location. That's all good stuff, but it doesn't mean anything until I get a route. And me making number 10 happen now doesn't mean anything until we get a route, because everything stayed. But I think you've been informed, and I know Commissioner Sullivan has talked about this in other routes, that we want to take seriously the legislative instruction to us to give due consideration to putting facilities in the right-of-way on a parallel basis. I think that's what they were saying to us. We could be wrong, but that's a discussion that we need to have. I know why your engineers don't like to do it. I know why that happens, because our Department of Transportation can be difficult to work with. There was a statute put in place because of that, okay, requiring certain timelines from them. How that marries up with your process, I'll let you figure out. But I'm inclined to make a serious look at, not whether we add it to as a route alternative or not, is for the future. But I'm willing to take a very serious look at Highway 10 from your route out by the Dakotas till you get to Motley. And so just put that in the calculation. It doesn't change whether you can qualify for standard review or not, okay? But it would maybe an alternative that we should be considering, at least is on my mind. I don't know if it's on Commissioner Sullivan's mind, but if there was ever a route, US Highway 10 is a pretty good looking one for a monopole structure in the right-of-way, like they do in Wisconsin, okay? And so it's there. And so I'm not going to move 10. A couple other things I do want to, as I looked at this record closely, I want you to make sure is fully discussed in your record going forward, okay? One is this jumping deal, okay, that you talk about on the different ways of doing the single circuit now versus double circuit. And so you talked about jumping. So you just have your engineers deal with jumping and explain it a little bit better, because I had a lot of questions. I'm not going to delay it today to ask those questions, but I want to see a robust record on what that jumping means. And then I also want to see a robust record on crossover, on cost of crossover, technical aspects of crossover for 115 kV on up, because you're marrying with several different lines. And one of the best mitigations that we have is to human impacts is a crossover. It wasn't well developed, I don't think, in the Northern Reliability Project Minnesota had. We were kind of creating that as we talked through the process. I want your people up front to have a very thorough discussion of how lines, the double circuit 345 kV crosses over the existing partner lines that you would be following, and a thorough discussion of cost and technical concerns related to that. And so I just wanted to throw that out there. I've saved a whole bunch of slides that I didn't put in here to move things along quickly. But those are the things that jumped out at me when I was reading the CN application, which is very early. So just wanted to get that out. And you don't need to respond. Madam Chair, I'm ready to make a motion if everybody else is.
Okay.
Madam Chair, I would move 1, 3, 7, and 9 for consideration. Again, I understand a little bit of confusion as to how this was being dealt with. I apologize for that. I was trying to get that clarified, but a lot of our staff on this matter were up in places like Hermantown this week, and so I didn't have a chance to talk to them until this morning.
Commissioner Tuma, I don't think it's a matter of like confusion. I think there are different procedural routes the commission could choose, and like what you outlined isn't wrong. Like, and as Ms. Verhalen said, we could do 3 and later decide we're going to send it. We're not going to send the CN to informal review. Like, I saw enough evidence on the record to just like make that decision now. I understand we could later change it, so it's like a little bit of potato. So I think your motion is fine with the understanding that, that like as different projects come in front of us, the commission should not set like because you're doing this path in this, for this particular transmission line, that means that is what should happen in this particular case, because I think each, as you know, like all, even though they're all in tranche 2.1, or these cases are, there are going to be differences. This one uses a significant portion of, or will likely use a significant portion of the right-of-way, as you likely pointed out. I'm like still driving at what is a transparent process for the public to weigh in on the CN and the route, and what gives the commission like a clear record too. And so I think your decision option does that. And I'd also just say to the applicants, like, I think you did a nice job of laying out what procedural path you recommended we take, and just because we're not doing what you recommended in your filing or changing now at the table, like, we can work with that too. So it's just a dynamic situation for staff and for commissioners. So, but I support your motion. Any other discussion? Commissioner Hom and.
Thank you, Chair Stephen. So one comment, I think the biggest advantage, set aside efficiency and other thing, is a public will deal with only one meeting rather than two different meetings with a very confusing statute, very technical word, and very technical data. Hopefully this joint meeting will give public more chance to weigh in, an easier way to weigh in. That's why the comment and reply comment, I have no concern, because that's a lot easier for public to weigh in. But if you go into the contest case, that's okay too, because there is a more legal cross-examining that testimony. That's another benefit of that process, but that will have a higher bar for public anticipation and participation. So that's why there's a pro and cons, but at the end of the day, if you have this single meeting, public doesn't have to worry about what they are talking about. They can talk about this project one way or another, whether need portion or route portion. Then we can take it into it, we can separate them, and then we can reflect in the right place. I think that's our duty, because we have an ability to understand that better than general public who doesn't have a time to understand and follow this thing every day. So hopefully we can have a better process by joining this one and have a better public process. And then I can support your motion.
That's the intent, yep.
All those in favor of Commissioner Tuma's motion, please say aye.
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 Aye. Opposed, the motion prevails. Okay, do we have another thing before lunch?
Got one more.
Oh, we have one more. Great, thank you, everyone. Mr. Labby, good morning. When you're ready, please introduce this item.
Good morning, Chair Stephen and Commissioners. Item number 6 is for docket number ET3E002/CN-25-121 in the matter of the application for a certificate of need for the Gopher to Badger Link 765 kV high voltage transmission line project. The questions before the Commission are: should the Commission accept the certificate of need application as substantially complete? Should the Commission authorize review of the certificate of need application using the informal process, or refer the matter to the Court of Administrative Hearings for contested case proceedings? Or should the Commission consider any additional procedural items? Commissioner Tuma filed a new decision option on Monday, April 6th. Staff notes some minor corrections to the decision options in the briefing papers. In decision option 7, staff did not reflect that the Department of Commerce supports decision option 7. Additionally, decision option 9 accidentally refers to Gopher to Badger project when it should have referred to the Power On project. Lastly, staff inadvertently recommended adopting decision option 14, which is no longer being recommended. Staff notes that Commissioner's new decision option, as well as a handout about transmission line structures, are located on the back table, and I also have copies up here as well. Staff has no further remarks, but is available for questions. Thank you.
Just to be clear, number 9 should have been Gopher to Badger, right?
Correct.
If the parties would please come forward.
Madam Chair?
No, we're not. Just a second.
The Houston County Administrator is here.
Okay. Well, I'll take appearances when we give everybody a chance to come forward. I don't know if anybody, is anybody online for this, Mr. Lobby?
There's a few online.
That are the parties? Or no? Okay. If the parties that are online could please turn your camera on and state your appearances for the record, we'll begin with the folks online. I can't see who they are, so sorry I can't call on you. Go ahead.
I can say, this is Steve Porter, Director of System Planning and Operations at Dairyland.
Sorry, Mr. Porter, you're with Dairyland, did you say?
Correct. Correct.
Is there anybody else online that wants to state their appearance? Then, starting on my far right, Mr. Pranis.
Kevin Pranis on behalf of Cuyuna, Minnesota, North Dakota.
Good morning. I'm going to jump over just because of a little bit of introduction on our roles in the project. My name is Lisa Agramonte. I'm with the law firm of Frederickson and Byron. I represent Xcel, one of the 2 co-applicants in this proceeding. Seated to my left is Christy Brusvin. She represents the co-applicant Dairyland Power Cooperative. Xcel Energy will be leading the CN effort. Dairyland Power Cooperative will be leading the routing effort. So just wanted to help set the stage for where to direct specific questions.
And Ms. Overland.
Carol Overland, Legal Electric, representing North Route Group and No 765 MN, and there are members behind us. Also, the Houston County.
And they're members of.
Of the No 765 MN, and then North Route Group. I don't see anyone here yet. Great. Oh, yes, I'm sorry, Frank. They are here from North Route Group, and that was an intervener back in the CapEx 2020 project, the Hampton to La Crosse project. And also here is Houston County's county administrator. I'm not representing them, but I want to make sure you know that.
Okay. But Ms. Overland, just to be clear, you're representing the NRG and the No 765 MN group.
Correct.
Great, thank you. Dr. Lieb.
Commissioners, Sydney Lieb with the Minnesota Department of Commerce.
And go ahead, Mr.
Madam Chair, Commissioners, Brandon Crawford with the Citizens Utility Board of Minnesota.
Okay, and then the gentleman from Houston County, did you want to speak or state your name?
My name is Brent Parker. I'm actually the county coordinator for Houston County.
Okay, thank you for being here. So we'll begin with the applicants. There were late filed decision options, and I'd just like your thoughts overall on procedural path today.
Thank you, Chair Sieben, Commissioners. We're here for a completeness determination, and we ask that the Commission determine that the application is complete to stay the Certificate of Need proceeding pending the filing of the route permit application, and that the 2 applications be reviewed jointly. Specifically, we support staff recommendations 1, 3, 7, and 10. And I'll note that when the applications are processed jointly, the alternatives evaluation and development will occur during a scoping process, which would run concurrently with the joint applications pending before the Commission. We do not support decision option number 11. I know we had some discussion about DER's requests for information in addition to completeness requirements as being more appropriate for discovery, and certainly with the stay of the proceeding, we think that should be deferred. Lastly, Commissioner Tuma submitted 11A. Applicants have no objection to adoption of 11A, and we are available for your questions.
Okay, thank you. Commissioner Tuma?
Just one adjustment to 11A. I won't put up all the schematics that I had, the pictures from your application for the CN. I think I got a little confused, and I think it's appropriate to know that segment 2 is a double circuit, and it will join with and follow essentially, when you get the route permit, what we expect is going to follow that additional line that you had. And so when I looked at your figures, I saw that you had the guy wire one, and as I read a little closer, and Mr. Lobby helped me out, that probably the more likely consideration still it would be a double circuited 345 kV single monopole versus a double circuit guy wire one. And so when you look at my decision option at D on the second page, it said guy lattice structure is one of the 3 structures to consider. I think that should have been a steel tubular monopole as opposed to the guy wire. And again, that to me is the one that most farmers are going to gravitate towards, is going to be either that or the double pole one. And so I'd like to modify it to include just the steel tubular monopole versus the guy wire one, replacing that. Is there any concern with that?
Chair Seaman, Commissioner Tuma, I was a bit suspicious when you wanted a guy wire evaluated, but I understood. There will be further analysis about the actual technical feasibility of these alternatives, and I'll just mark the spot that if really the applicants conclude that it simply cannot be built double circuit, we will make that notation and support that in the record, and would probably ask for relief from this condition to do any visual simulations if it is proven to not be workable. But I have no objection to you putting this in as a decision option, recognizing that we'll develop the record on it.
And that's fine. I mean, as of now, you did indicate in page 150 of the application that the monopole would work. I agree the guy wire didn't work, and I just was going off your figure that you had where the guy wire was in there, and so I was just grabbing that. But as long as we're on the same page, and I also agree with you, you find it's technically unfeasible to use these as a double circuit. And that's where I probably was thinking maybe the monopole, because of the height for a double circuit, may not have been technically there, but we saw in there that you kind of did mention it, so it's worth considering, and I know that's a lot what the agriculture community is going to be wanting to understand. So we're tracking, I think. Then the only other difference that I had is we didn't talk about 14, and our staff has come up with a new 16, and this is the request to administrative law judge for intervention. And I guess we didn't want to just say we're not going to consider intervention. They came up with language, Ms. Fry did, was a new 16. Instead of doing 14, we would suspend the petition for intervention of NRG/no 765MN until the commission reconvenes on procedural issues after the route permit application has been filed. And so we didn't want to just ignore an intervention request, but it would be just delaying that until we come back after the petition, and then more likely we'll probably refer to an ALJ at that stage to determine. But we're not ignoring it, but we're not dealing with it, I guess is what we're trying to say. Any objections to us doing a decision option like that?
Chair Seaman, Commissioner Tuma, that makes practical sense to me, and no objection.
And Ms. Kaler, I don't know if you have that. I don't know if someone had that one.
That is being passed out right now.
You have it. Okay, staff has. Okay, everybody has it. Good.
But it's not online,
It's not on the screen.
right? So maybe we can just get it on the screen.
I don't know. That's what I was asking if it can be.
And considering it's about Miss Overland's clients, are you going to ask Miss Overland if she supports this when she sees it?
I'm sorry, could you repeat the question, please?
Did you have a chance to see TUMA New 16 yet? That's what was just handed out. It basically just says the commission won't decide on the petition to intervene at this point.
And essentially, that's just a postponing, and we could live with that, or 13 or 14.
And then, Madam Chair, to the department, 11, we did adopt 11 in the prior 765, but I'm hearing the comment from them, you're going to get that information. This will be a conversation about when you get it. If you still want 11, I have no problem with doing 11, but what's your desire?
Chair Sieben, Commissioner Tuma, the department wants to make this process as efficient as possible, so we would prefer that the commission ask that information be filed. I think anyone who's been on my side and had the joy of sending discovery requests to utilities or other parties knows that they don't always answer the question as clearly when I ask it as they do when you ask it.
So to the applicant, we did this last time. The 765 is a new thing, and I think we're trying to get our brains around that as much as possible. So I think the mantra amongst our staff in this process early on is to work with you prior to applications. The department also has some duties that we're trying to get them to help us out on prior to applications. I don't see any damage in asking this, even though it's stayed, asking you to get this into the record as soon as possible. So give me your argument why you feel so convinced that we need to not do 11.
Chair Sieben, Commissioner Tuma, it's a matter of process. The department has said we've provided everything that was required for a complete application. We should be moving over to the proceeding and then doing the development of the record through that proceeding. Also, understanding where I see you're going, if this were to be ordered, we would ask that it be submitted at the time of the route permit application rather than 45 days from now.
Ms. Lee, be okay with that?
Dr. Lieb.
Chair Sieben, Commissioner Tuma, we would like it submitted as soon as possible because we want to make this process as efficient as possible. If there's a reason why the applicant isn't able to get it and they'd prefer to do it with the route permit, that will take it as quickly and as efficiently as it can get to us. But we would rather it be filed with the commission rather than come through a discovery request.
When are you thinking about the route permit? Filing?
Currently scheduled for October of this year.
Is 45 days too soon, or would you?
Is it 45, Commissioner Tuma, is 11 45 days of this order on application completeness?
That's correct.
So that is very different from November.
Chair Sieben, Commissioner Tuma, it is. We have a one-year process that will commence when we join these proceedings together. It's supposed to be sufficient time for all of this to occur. I understand people wanting to get a jump start because, as you said, we're moving along a little bit faster. We have a new voltage that we're exploring. We also have another docket that's moving ahead of this one, where information will be shared in that docket. I think 45 days for the scope of the questions that were asked is a lot. And so I would request at least 2 months. And really, we think it's more appropriate that it be submitted with the application for the route permit. So when that process will then begin again, parties like Ms. Overland's party, Overland's clients, and everybody else will then be able to engage in discovery.
45 days after the order. I mean, the order's not going to come out for a month. So that's 75 days right there.
I heard 60 days. You okay with 60 days? A doctor leave, sorry.
60
I'm
days
gonna call you
sounds,
commissioner, so.
60 days sounds great.
Okay. So I'm ready for a motion, but I don't want to.
I don't know what you're thinking for a motion, so,
Well, I'll tell you, I was going to do 11 at 60 days, if that's what you're
but I
concerned.
mean, for everything else?
Oh, sure.
Is that what you're saying, you're ready for a
I'm
motion?
ready to do a universal motion, but I don't want to stop anybody from asking questions.
Commissioner Sullivan.
The only thing thank you, Chair Sieben. The only thing I would say to the applicants, since, again, this is the opportunity for me to say something publicly to you, is I hope you're looking at highway right-of-way. And I know you have to work with DOT, and that's difficult, but that's a priority in my mind, so.
Commissioner Tuma.
Okay, following pretty much staff's recommendations, and I'm going to track with, make sure I follow it, Mr. Labby. It's 1, 3, 7, and then 9, but modify so that it is Gopher to Badger and not Power on 765. 10, 11, modified to be 60 days after the order instead of 45 days after the order. It would be Tuma, new, what was that?
16.
Tuma new 11A, modified by removing from D guy lattice structures and replacing it with steel tubular monopole, and then Tuma new 16.
Is the motion clear for the parties?
I'm seeing,
First
I'm
of all,
seeing frowns and first I'll start with Mr. Lobby. Did I cover the landscape that you needed me to cover?
Yes, sir.
And I'll wait for Ms. Brusman's frowning face to figure it out what I did wrong.
Chair Sieben, Commissioner Tuma, Christy Brusman has brought to my attention that we are in docket 25111, so we need to designate the appropriate docket number to consolidate with, and we do have a route permit number, and she may be able to help me with that.
And, sorry,
This is
just
number 9.
Number 9, yes. Chair and Commissioner Tuma says consolidate this proceeding. This proceeding is 25-121, so we're not consolidating with anything. And so I think that language is just incorrect. We want to stay until the route permit application has been filed, and then you'll take up the procedural matters at that point in time.
So are you saying not to do 9 is what you're saying?
I'm saying that we don't want the language about consolidation because this is that docket. There's nothing to consolidate with. We're just staying this certificate of need proceeding until the route permit application has been filed.
Okay.
and that's covered in number 7.
Correct.
Commissioner Tuma, my understanding when I mentioned at the beginning was that I had inadvertently just put the wrong name in there.
You weren't actually saying for just to do 9.
No, not to do 9. I was just correcting that I said, so I apologize for
That was my confusion, so my decision options would not include 9.
Sorry for the frowny face, but thank you for fixing it.
That's all I needed. So, to make sure everybody's tracking, it's 1, 3, 7, 10, 11 modified to 60, Tuma new 16, and Tuma new 11A with the modification of about the different structure.
Ms. Overland.
Thank you, Madam Chair, Commissioners. The point of consolidation, and it wasn't discussed in 117, and I'm not seeing it discussed here, is that we have one large line. The 765 is all one project. And in their need statements, they are exactly the same in 121 and in 117. Section 1.4 in the applications, the whole chapter of Section 6. When they discuss need, they're talking all of this line. They are talking FEMISO projects 22, 23, 24, 25, which is 117, and 26, which is 121. Now, also, 117 is consolidated the former certificate of needs dockets, 117, 118, 119, 120, and over here we have 120 and 121 consolidated. They all need to be consolidated because this is one big project. It's just like the CapEx project, where we had a line going from Brookings to the Mississippi. Same thing. And then in that one, we also had, in the certificate of need, Fargo down to St. Cloud. It was not confusing, and I think under oath, probably those of us who were there would have to say, yes, it was not confusing.
Ms. Overland, that's really helpful, and I think I get where you're, because I read your thing too. I understand where you're going. Can we let the applicant explain why the CN is chunked up? Like, I understand from the previous discussions why the route permits are, because they're different segments and we want to, consider those in the area where they are. But again, for Ms. Overland and commissioners and my understanding, what is the efficiency in not consolidating just the need? Because we're not going to build one segment of the transmission line. We're not building like a bridge to nowhere. We're not going to do just a segment of it. And so how do you think about the procedural path of the overall scope of the project just as it relates to need, and why it's best to keep needs separate?
Yeah, thank you for the question, Chair, Commissioners. Number one, these are multiple projects. MISO designated them, as Ms. Overland noted, 22, 23, 24, 25, 26. These have different ownership structures and based on segment. The owners of 22 through 25 were able to consolidate their efforts because they have different overlaps for different segments within those pieces, and chose to submit one CN application. There's nothing in the statute that requires further consolidation or mandates that everything be included. At some level. Everything on the transmission system is connected. You're evaluating different pieces of LRTP 2.1, including the proceeding before this morning in the docket. There are different geographic regions, and we also need to break it up somewhere because you can't staff a coast-to-coast series of open house meetings and proceedings of the scale that will be required here. So we believe that it's appropriate to proceed as we are proceeding in the two separate dockets.
On need, that's helpful. Any follow-up on that?
Sure.
Commissioner Sullivan? Is that a hand raise?
It's sort of a hand raise, and it's kind of like, I hear what you're saying, Ms. Agramonte, but it is all the same project. They're Tranche 2.1 projects. They're Tranche 1 projects. They're all justified at MISO based on a need determination. And so I think actually from an expediency perspective, if we had one large CN for all of the lines, that would be expeditious.
Would it reduce the costs in your estimation?
I think
Ms.
from a
Agramonte?
scale, sorry. Sorry, I thought you were asking me.
I was going to, but I should probably ask.
Ms. Agramonte.
Ms. Agramonte. The procedural costs of consolidation on the CN side, would that substantially reduce the costs of the overall costs of administration?
Chair Sieben, Commissioners, I don't believe so. By combining the CN and the route for the 26, which is able to go faster than the rest, it's all the same process. You're going to tag the CN onto the route process, so there's no savings there if the CN were pulled apart and put on the first CN for 22 through 25.
I think that's, like, for me, the most persuasive argument is that we already decided and see the value in doing separate route permits. And if we can match the CN up to that route permit segment, then procedurally that should be pretty, as best we can do for a long project overall, like for the public to be able to understand what's happening so they can, the process is married from the CN and the route permit rather than marrying up the CNs and then having separate route segment permits.
Chair Sabin, may
Go
I
ahead.
add? Thank you. Also, if we were to do as Ms. Overland proposes, then we stop the routing for 26 and it's got to follow later. So we think there is efficiencies in staggering processes for the commission, just like other 2.1 projects are not all going on the same schedule, and that'll allow them all to get done in a more expeditious manner.
And Ms. Agramonte, if I know you're not speaking for all of the applicants along the whole, we're only looking at your segment here, but am I correct? And I'm not an engineer, but could you or could you not like build segments of it, of consecutive lines? So for example, like what I'm saying is if we would deny a CN for this project, the other segments could still go ahead if the commission decided to grant a CN and a route permit.
Chair Stephen, Commissioners, I don't know that I have an engineer here with me to be able to answer that. I know that they're evaluating kind of timing and what can be energized first or second. There would certainly be some viability considerations if the commission were to deny one of the segments, but I don't know the full ramifications. And you're right, I don't speak for the other applicants, and this certainly wasn't noticed for the Power on Midwest docket to consolidate. So I don't know that this is a proper decision point for the commission
No,
today.
and I'm not proposing we make any decision point on it now, except to say that this is likely something that will be discussed in the CN proceedings that go forward too. Like the overall viability of the entirety of the project will be discussed.
Chair Stephen, yes.
Commissioner Sullivan?
I mean, I guess I look at it like, you know, we can break them out and have certificate of needs for each line, and each line, I mean, the MISO cost benefit analysis for each of these lines is like 3 to 1. So there's plenty of room, you know, like they're based on the MISO analysis, we're going to do our own analysis. But, you know, I think if you start removing lines from the portfolio, the cost benefit of each of those lines will go down. I mean, it is a system. You get the benefit from it being a network and from a system. Mm-hmm. But we can still do it. I mean, I think it fundamentally it comes down to the utilities just didn't, you know, get together and decide how they wanted to run a CN together. I mean, like that's fundamentally what it is. You said they're differently owned. Okay, that's fine. We'll just do it separately. But I think it's just going to, at the end of the day, it'll be more work. It'll be more difficult for the public to understand what's going on, and it'll be more work because they are, like MISO approved them as a system of lines. Mm-hmm. And we could do the same if we want, but we're not going to do that because the utilities own them individually. It is what it is. It doesn't.
And we're mirroring it with the route permit.
Yeah,
so
I mean, it is what it is. It doesn't.
And making it clear.
We're doing the best we can. Yeah, exactly. Commissioner Hom has much more experience on this than I do, so I'd be curious if he's like, no, Joe's wrong.
No, thank you, Chair Stephen. No, nobody's wrong. I think everybody trying to make it more efficient and transparent as possible to the public. In prior docket, I mentioned the benefit of joining CN and routing. A lot of public comment, what I was working on this issue was cannot distinguish between need and routing. That's why I was supporting the prior dockets. Joint CN and routing will help public to understand better. I'm sure the people in the southern Minnesota doesn't want to go to the Minnesota Power Hermantown area and working on it. That's why I think it is MISO-wide decision. However, state statute is very clear. Each applicant has to make their own case based on their own merit claim, which will include MISO's study, but also they may have a geographical or utility applicant-specific information and discussion. So there is a pro and cons of consolidating, and so I was working on the CAPEX 2022. That time, there wasn't MISO project. There was 11 Minnesota and surrounding utility get together and they designed what we need for the whole state, and they did it. That's why they did it with a single CN in that proceeding. However, they break up the routing because there's no way public can participate in so many of those public meetings. But also in that discussion, I heard a lot about people complaining, we are here too late because you already discussed the need portion of it. So that's why I think there is some benefit of doing this joint CNN routing. Clearly, there is some potential confusion too, because why do we have to keep discussing this need? But also state statute is very clear. Minnesota statute doesn't say because MISO says so, we have to approve it. So I think that's why we have to go individual CN by CN.
And I mean, I think, Commissioner Hom, I think the most important thing is that it's a transparent process for the public, and then how we figure it out on the back end is, we just got to make sure that people understand what is being presented to them. And I hope the applicants don't think I'm not directing anger at you. I'm just like, it's a little frustrating process, so it is what it is.
Your motion, Commissioner Tuma, is clear.
Clear to me, but if it's not clear to you, let me know. I can walk through it again.
Any further discussion on Commissioner Tuma's motion? Hearing none, all in favor, please say aye.
Aye.
Opposed, the motion prevails. Thank you, everyone. We'll take a break and then take up item 7 right at 12:30. Commission is adjourned. I mean, sorry, I didn't mean that. Is in recess.
We reconsider that.
Can I leave? Yeah. commission will come back from its recess and we'll take up our last item of the day. Mr. Noyce, please introduce item number 7.
Yes, good afternoon, Chair Sieben and Commissioners. Item number 7 is docket number E002/M-25-142 involving Xcel Energy in the matter of their 2025 Integrated Distribution Plan. The question before the Commission is, should the Commission approve, modify, or reject Xcel Energy's 2025 Transportation Electrification Plan? Staff compiled and revised decision options and note copy error in the preferred decision option table. The Coalition for Clean Transportation is erroneously labeled CTT instead of CCT, and they support decision option 3. We have representatives from Electrify America, Xcel Energy, Weave Grid, Native Sun Community Power Development, the Alliance for Transportation Electrification, Fresh Energy, representing the clean energy groups, the Coalition for Clean Transportation, the Department of Commerce, Switch, the Office of the Attorney General Residential Utilities Division, and EVgo available for questions. Staff have provided copies of the compiled decision options as well as a late filed decision option by Xcel in the back of the room. I have no further remarks, but I am available for questions. Thank you.
Real quick on process, I want to make sure I got the right thing. I'm looking at the April 8th revised and compiled preferred decision options from staff. That's the one I should be working off of, right?
Correct.
And that does not include the April 8th submission from
Xcel. Correct.
And did you say that the April 8th filing is available, or it was e-filed?
It was e-filed and available in the back of the room.
But there are no other late decision options? Like the Department New 32 is reflected in your...
Compiled and revised decision option list. Correct.
And there are no other late decision options?
No.
Okay. So this is a big record, but we have a lot of record development. So, and a lot of parties. So why don't we just start with commissioner questions, and then we can have the parties introduce themselves if someone has a question for them.
Come on up.
So the company can come forward. I'm sure you'll get questions. And we'll start with Commissioner Hom.
Thank you, Chair Sieben. I think it will be a more high-level question to probably everybody. Based on what I read, I think directionally everybody agree in the direction. I think there are some difference in how we carry out that. So I think I want to confirm that from the company. Is that your understanding?
Chair Sieben, Commissioner Hom, yes, I would agree with that.
And please state your name for the record.
Excuse me, Lauren Steinhauser on behalf of the company.
Okay. Thank you. And then can I ask a department? And then one of the clean organization representative, whoever can speak.
Dr. Lieb, state your name for the record, please.
Chair Sieben, Commissioner Hom, Sydney Lieb for the Minnesota Department of Commerce. Could you repeat the question?
So yeah, based on my reading in high level, I think everybody, we are going in same direction, but there are difference in how we carry that out. Is that correct understanding?
I think that's a fair characterization.
Thank you.
Good afternoon, Chair Sieben and Commissioner Hom. I'm Nick Haig, representing Fresh Energy on behalf of the Clean Energy Groups.
Thank you. Same questions?
Can you repeat the question?
So it's a high-level question. The directionally, all parties agree with how it is going. In the meantime, we have some difference in how to carry that direction out on this.
Thank you, Commissioner Hom. I believe that is true, that there is directionally making things, moving away from company ownership of electric vehicle charging assets and moving in direction of active managed charging program had widespread support among competent parties. I think that there are some fine-tuning things like the vehicle to grid demonstration project and maybe some of the time of use rate stuff, that there's still some stuff, but directionally very much agree.
Okay, thank you. And then for the company, I think this active managing is the key to get the best value out of this charging, because that way you can manage potential obligation to MISO peak demand based reserve margin requirements. And also you are fully utilizing value of this charging station. Is that company's understanding, and that's the direction you are trying to go?
Chair Sieben, Commissioner Hom, yeah, we definitely want to leverage the value of the technology that's there, and I think the kind of where we found consensus with everyone is that it's still pretty nascent, and so launching it as a pilot, figuring out how we do that to leverage those different elements and put them all in place is where we hope to go.
Okay, thank you. And then also, last week we approved the Capacity Connect, and then also in that discussion, I think it was strongly emphasized that delivery of the DER management system plus fully co-optimizing system. However, and also company made it clear that yes, also we have to pay attention to MISO obligation, but given that you can still try to co-optimize, try to get the best benefit of utilizing distribution system.
Chair Sieben, Commissioner Hom, I believe the same is true here.
Okay, so that applies here too. So in that vein, what is the current status of your management system deployment schedule? And then how soon individual charging station can do it, but also you have to optimize it with a multiple charging station. What is the current status of it?
Chair Sieben, Commissioner Hom, just to make sure I understand the question, and I'm probably going to have to call up one of my colleagues, but the question is, like, if the program is approved, or if the pilot is approved, how quickly could we get to a place where we are actively managing chargers? Yep. Okay. I'm going to phone a friend here.
Hi, state your name for the record, please.
Lucas Roach. I'm the product portfolio manager for our electric vehicle programs at Xcel Energy.
So question is, if this program is approved, how fast can you deploy this active management system, not individual station, but system-wide?
I would say, thank you for the question, first of all, and I believe we could have it up and running by probably Q3 of this year. We do have the systems in place in other jurisdictions, and the systems that we leverage are the same systems that currently run our Optimize Your Charge program. So it would be transitioning customers from that platform to the Active Managed platform, and then we would have to set up some processes around signal reception and communicating that signal, but those processes are in place in our Colorado service territory, so we could leverage the same sort of operations plan that we have out there.
So in other words, you have a software and then hardware, they can send the signal to the individual charging stations and then aware of the MISO grid system, so it can interact along with your distribution system reliability and then also NSP system reliability. All those can be co-optimized?
Correct. So we have the system in place for the bulk system signals as well established. This would be the first time we are sending distribution signals as well. We have laid out a plan to do so, and we do have integrations with our system planning group and our organizations that operate the distribution system to set up a streamlined approach to send distribution signals to those customers that we deem to be distribution optimized based on the filing.
Okay, thank you. I think.
Commissioner Partridge, or did you have something? A question?
I'm done with the question.
Okay, I have a handful. They're not on the same topic. Okay. So I guess actually just staying with the charging perks, I think one thing that I wanted to talk through is that, and I've got it, where am I here? So reflected in decision option 19 and 20, going into updating the time of use rates for the EV Accelerate at Home customers. Understanding that, I guess this is the question. So my understanding for the company is that you are planning to transition the EV Accelerate at Home customers over to charging perks once that is available. Is that right?
Ms. Steinhauer.
Excuse me, Chair Steven, Commissioner Partridge. No, those are two separate. So it's optimize your charge, excuse me. Those customers would be shifted to charging perks or have the option to shift. EVAH and charging perks are separate.
Okay, so EVAH, those participants would continue on that program and continue without being transitioned. Is that correct?
They would not be transitioned into charging perks. Our proposal is to transition their rate to the new time of use rate that's going into effect this year.
Okay, but you're not going to do outreach to them to get them over into managed charging?
No.
Okay, so I guess that was something I was unclear on, but changing them to the new time of use rate, and I think that Mr. Haig has several or put a lot of comments into the record on this matter. Transitioning them over to the new time of use rate, as I believe it was the Clean Energy Group's analysis showed, would pretty dramatically increase those customers' bills. I think it was 65%, just because 85% plus of their, or was it 87% of their energy consumption or electricity consumption happens in those off-peak hours. I'm a bit concerned about that. I think that, as Commissioner Hom said, we're all moving in the same direction towards trying to optimize those loads, but also encourage those beneficial loads if we can charge our cars in off-peak times when there's excess, very low-cost renewable energy. It seems counterintuitive that we would want to jack up their bills 65%, and it also seems like potential rate shock for those customers. Can you speak to that and what you plan to do? Because I don't like that idea. I haven't made that obvious.
Chair Steven, Commissioner Partridge. So the existing EVAH rate is based on, it's a 3-period rate that was based on the residential time of use pilot. From, I think, like 2019. That pilot no longer exists. The Commission has approved a 3-period time of use rate that's going into effect. And so in order to align rates across the residential class, we need to update, essentially, the EVAH rate that does significantly increase their, potentially increase their bill, depending on the time of charging. And so there would obviously have to be a bunch of communication around that so that that would not hopefully come as a huge shock, but educate them on what would be coming. But in order to align the residential rates with the approved Commission time of use rate, that one does need to be updated. Otherwise, we have different residential 3-period rates happening, and one is just for a customer who's charging their car.
Okay, so what I recall is that you do have special rates for electric heating customers that are different from the time of use rates that a standard customer has. And that recognizes that they have a different energy consumption pattern and a different load curve for their pattern of usage. And if I'm recalling, although I recused from this, there was analysis in that record that showed that for customers who have a heat pump that they're using for heating, it aligns with lower cost periods of consumption and therefore justified a lower rate. Mr. Haig, I'll go to you next, but seems to me like this would be a similar situation if you've got 87% of your consumption happening in off-peak, that aligning that very unique and very different usage pattern and load curve with a standard load curve and consumption pattern doesn't, like, it seems like that would justify a different treatment or a different rate structure.
Chair Stephen, Commissioner Partridge, I appreciate the space heating example. I know that in creating the 3-period time of use rate that the Commission approved, we took into account the EV charging periods and the off-peak time periods. And I'm going to quickly get in over my skis. We have our rate specialist here. I would like to bring him up to get just more into like why this, for these customers, for this use is different than the space heating.
Okay.
Great.
Welcome. Please state your name for the record.
Nick Pollock for Xcel Energy. I'm happy to talk about this. This is a complex matter, and I understand the confusion. I think I'll just pull back to, something that actually Commissioner Hom said in the last TOU docket hearing that we had, and that what the company's really doing with our time of use rates is first analyzing, the peaks and the correct time periods for the time of use, and looking at that at a system level. And so that's kind of the first step of designing a TOU. And then we look at the cost to that class, and we have a very robust, what I'd call pretty scientific model, the cost duration analysis that we use to assign all the costs to hours. And then we get those hours to a specific time period. So we've got 2 analyses that really bring together both the periods and the rates within those periods. And that's the high level. And then what we do with that then is, solely the goal of that is to provide a price signal to all our customers, right? And so that signal is not financial engineering, but is a representation of the cost to serve them during those periods, right? So we have an off-peak, a mid-peak, and an on-peak period. And so by looking at those periods, it's sending a signal to all customers what the cost is to serve them during that period. And that takes into account both the residential class, all the costs that this body approves to be allocated to that class in a rate case, and then also the analysis of how to split up that cost into different time periods. And so that's a little bit different than the experience with the space heating rate. That design is based off of a subset, and not necessarily a holistic system view of dividing into periods and in more robust analytics. It's more looking at just specific customers and the class associated with those customers to see what their total base revenue contribution is, and equating that base revenue contribution between space heating and non-space heating. So it's really more of a limited analysis, really only applicable to those types of customers, whereas we're doing a much more robust system and class analysis on the residential class. And therefore, that really supersedes what we're doing in other pieces of that. And I get that that's complicated and different. But the analysis for the residential class is very much more sophisticated and should be relied upon by the commission to set prices for residential customers. Just as a rate design person, my concern about having multiple residential TOUs is sending the signal that it costs, there's a different cost for different types of usage on our system at the same hour. So for example, if we were to set different periods or different cost levels, to me that sends a confusing signal to our customers that that the cost to serve them is different by the different use type. So an EV customer versus a home. So that's the analysis that goes into that, and I'm happy to, shed more light on this, but I've probably talked enough for a little bit.
So my understanding, though, Mr. Pollock, is that if I have an EV, I'm consuming a lot more electricity. Within our electric rates, we are building in fixed costs and variable costs. If I'm consuming a lot more energy, I am going to be paying more of the fixed cost than someone who is using a lot less energy than me. Yet, I'm not actually, my extra payment in fixed cost is not commensurate necessarily with my contribution to extra costs. So I guess what I'm saying is that I think that the EV user is quite analogous to someone with an air source heat pump, especially when we think about the fact that they're using a lot of their electricity off peak. If I can ask Mr. Haig to maybe provide a response. I know you put a lot in the record on this. I don't think I'm doing it justice here after 6 other items. I'm not as articulate as I'd like to be, but perhaps you can provide me some clarity here.
Thank you, Chair Sieben and Commissioner Partridge. I want to say I do think you've done a great job articulating the gist of our position here, which is that, I think that we want to be sensitive to the ideas that Mr. Pollock is talking about, where, in this residential time of use docket, Xcel came forward and said, our changes to cost of service for off-peak electricity has changed. They've done this analysis. These are the new numbers. That said, I think that because of the special nature of electric vehicles, how they're used, how they're charged, that docket didn't take into account sufficiently the bill impacts on those customers in particular. And then also maybe that the treatment of electric vehicles, because, as Commissioner Partridge said, they contribute more, they consume a lot of electricity, they're very, very flexible load compared to typical household load. It can be shifted around more. It can be used for grid optimization in ways that other loads can't. That there is some kind of reason to differentiate it and ensure that those off-peak rates remain as affordable as possible. So I do think these are the key points that we made in our comments, and trying to be sensitive to those things like the cost of service, but thinking that it still does deserve a little bit of special treatment, much like space heating. Thank you.
Yeah.
Thank you, Chair Sieben. So follow up to this exact same question, I'll ask a company first. So we are talking about certain facts, potential 87% increase in the rate impact to EV customer. We are talking about 2 different things. One is cost of the study, services study, and then time of use, time period. Which one is triggering this 87% increase? Is it one or both?
Thank you for the question, Commissioner Hom. It is being triggered by the analysis of the TOU periods. So solely, by that analysis. And so what the company is essentially doing in that analysis is allocating cost based on the resources needed during those different time periods, and it's recognizing the less inexpensive time period in the off-peak to serve, and so it is giving special treatment to the off-peak because that off-peak is set at 7 cents, roughly 7 to 8 cents, versus the on-peak period, which is more than double. So it is giving a special treatment. I think the challenge here and probably the hesitation here is that we're transitioning from, an old rate design that, we heard from our customers overall as being too heavy loaded on the peak, and it probably gave a larger or a lower rate than it should have maybe in the off-peak period. And what we found through our analysis is, and the model that we're using is that really the correct number is the number that we provided and that you all approved. And so, I recognize that EV customers, do use, it's an addition to their home load. But a lot of customers have other additions to their home load. And so, and I get the perspective of, treating EVs, it's a different load, and there's other benefits of EVs. So I really do appreciate that. And I own a hybrid, so I'm a plug-in hybrid, so I'm part of that community. But I would just qualify that, after a great study, the company I feel like has done really, really good work in designing those rates. And they do really reflect, our full complement of customers. And then the other caveat that I would make just for consideration is that if we did create a separate structure for, the 20,000 or so EV drivers in Minnesota, I'm not sure what the most up-to-date number is, that is contemplated by our current rate design. So, it might be the case where we would need to look at, creating a new number that drives costs up for everybody else to create a cost profile for EVs that is potentially lower. I'm not sure what that would be, but it is a zero-sum game, and so we would need to look at that further to make sure that that our costs are being recovered.
Yeah. I think I tried to make it simpler, but it's more complicated. So I'll ask you one more question. Let's say if I charge 100% of my car during the off-peak, what will be the bill impact?
I haven't done specific analysis, what I can say is that, based on our analysis, today, if for example, if you approve the transition to, the time of use rates that you approved previously, the cost of charging off peak fully would exactly align what our analysis is saying. So the cost would be equal to the rate design. Now, in terms of the bill, yeah. So I'm sorry, I'm getting to your question. So the bill would see an increase because our rates, previously were set lower than that. But our current analysis supports, that 7-cent off-peak rate. So, I know there's always a concern about raising rates, and we have that same concern. But it's really probably more of a situation where that previous rate was probably set too low. And again, we heard a lot of feedback from our customers that the on-peak was set too high, and the corollary then is the off-peak was set too low. And our analysis agreed with that, and you all approved that.
Okay, so that is the thing I was looking for. So compared to the existing EV rates and then what you are asking in transition now, prior you had a bigger difference between peak and off-peak.
Correct.
Now with the time of use, that difference is now shrinking. That's why now off-peak price is higher than used to be for the EV charging customer. So there'll be a rate shock.
Yes, anybody who is on the time of use rate, it will see that structural change. It's probably most pronounced from an EV customer, but anybody who takes that rate will still we'll still see that. And so, you know, what I would recommend is that that customer takes the time of use rate for their whole house, because they'll get the benefit of that off-peak rate for all their usage, and get a lower on-peak rate for their peak usage. And so in some it balances out, but yeah, I do agree there is a rate increase for that off-peak period and a rate decrease for the on-peak period.
Okay, thank you. Can I ask, fresh energy? So question is, you heard this discussion. Have you calculated what is the rate impact? 87%, is it the same way of charging from off-peak today to the transition into the time of use off-peak charging? So it's 87% is no matter what, you will have an 87% rate shock.
Thank you, Chair Sieben, Commissioner Hom. So the 87% is the percent charging that happens off-peak for the typical EV accelerated home user. So we did some analysis where we took the numbers, the percent charging by period, and just plugged out the old time of use rate numbers and the new time of use rate numbers, and the 2% of charging that EV accelerated home users are doing on peak, they get some savings out of that. The 87% of charging that happens off peak, those prices are being doubled. So the net result, after all that's taken into account, is a 65% increase in the average bill for an EV accelerated home customer.
So there is a bill impact, not the base energy rates.
This is the impact to the volumetric energy charge for a monthly bill.
So this is a very strange that do we have that much difference in the existing EV rates between peak and non-peak?
There are interesting conclusions about how much you need to incentivize off-peak charging. And generally, I would say a bigger difference between off-peak charging, you are more likely to get people to do the charging at the off-peak times when the costs are lowest, and people will optimize the use of renewable energy, and everybody will receive better electricity rates because EVs are contributing to the revenue requirement. I think the new rates are, this is a pretty significant, it's going from a 24-cent difference between off and on peak to a 14-cent difference between on and off peak. So it's a pretty significant change.
So I think both sides agree that the reason we have this discussion is because the difference between peak and off peak, 24 cents to 14 cents, 10 cents difference. Okay, thank you.
Okay. Thanks. I still want to keep going on this. Mr. Pollack, when you did your work on the TOU rate, what was your assumption for the average consumption for a residential customer in the residential class on an annual basis? Or monthly, whichever one you have top of mind.
Sure. Thank you, Commissioner Partridge. In the analysis, we don't really leverage I suppose there's like a computed average that you could make, which is just the number of customers divided by the number of sales that we have for the residential class. But really what it's looking at from a modeling standpoint is really just all the usage and the cost of that usage by hour. And then what we are reflecting in the charge is all of our cost assigned to those off-peak hours divided by all the off-peak usage. And so they are, it is a linear calculation. So as you have more usage, obviously there's a little bit more cost that shifts, to reflect that consumption. But it offsets on the other end because you use it as a divider as well. And so,
Let me
It
just-
scales, I guess, is what I'm saying. And so what it's delivering is, I guess what we talked about in the TOU hearing is that what it provides is, what the company's cost to serve is during that period. And so that's why it's a little different than the space heating analysis that just sort of looks at, just a bimodal situation of a customer with and without a space heating.
Let me ask you another question. What % of your rate goes to fixed costs?
That's a
that
good.
don't differ based on consumption, which is just explanation.
Sure. Yes. Yeah. It is quite a bit. So we
Okay.
are a mostly fixed cost.
Can you get that for me? And I don't need it right now, but if those in the back can try to figure that out in the next few minutes, that'd be helpful. My point is this. An EV user is using a lot more energy than the average residential user, just like somebody who is heating with a heat pump. That was the whole premise of the space heating rate. Okay, so they are paying for significantly more of the fixed costs. This is not about trying to subsidize or encourage or incentivize electric vehicles. It's about the fact that they are using substantially more electricity and therefore paying substantially more in fixed costs. And if you are charging them the exact same rate as a standard residential customer, then they are paying a lot more in fixed costs. I don't hear anything and didn't see anything on the record about how that's mitigated through this program. And the fact that 87% of their consumption is happening off peak, I think further illustrates the benefits of those loads. And so asking those customers to pay significantly more in fixed costs, even as they are bringing on these beneficial energy loads and bringing down costs for other customers, I'm not understanding, nothing you've said makes any sense to me. That's how I'm looking at this. If you feel like I'm not looking at this correctly, then please explain. But what you're saying to me now is not computing in a way that's giving me any reason to move off what I'm thinking here. And like I'm saying, I am not wanting to incentivize, encourage, or subsidize EV loads off other residential customers at all. I am just saying that if you are an EV customer and you are bringing on a load that is using up a lot of low-cost renewable energy at times of the day when others are not using electricity, therefore bringing down the overall fuel costs for all customers, I don't see why you should be overpaying for the fixed costs. Dr. Lieb has something to weigh in on.
Chair Stephen, Commissioner Partridge, I think from the department's perspective, we agree with what you're saying, and I think we understand why the utility is struggling. I think this is a really important point, but I don't think it's sufficiently in the record. Our recommendation would be, if you want to get the right rate based on the issues that you're appropriately raising, would be to order the utility to do a class cost of service study and propose a rate based on the class cost of service study to make sure that we are not penalizing, or if you don't want to over-incent the electric vehicles, then you probably need a more developed record with a class cost of service study.
Dr. Lieb, are you saying a class cost of service study specifically for EV customers?
Specifically for EV customers on a static time of use, non-managed charging rate.
Okay. Mr. Haig, do you have thoughts on that?
Thank you, Chair Stephen, Commissioner Partridge. I think on the surface that sounds appropriate. I was tripping over because we often call time of use rates passive managed charging, what you were saying there, but I think that does sound correct. We support EVs having been, downward pressure on overall electric rates. So, EVs don't, the fair share argument isn't really like what we're necessarily always going for, but I think we don't want to see 65% bill increase for customers. So if the path forward is to have kind of a better understanding of what are the real impacts of EV charging on utility revenues, I think that's a genuine step in the right direction in terms of developing the quote-unquote correct rate for time-of-use rates for EV customers.
Okay.
Along that lines, though, Dr. Lieb, class cost of service study assumes you're comparing a class of folks to other classes. So would it be, I was struggling with what we're studying here. Are we studying the old class and their contributions under the old program, or are we making some assumptions on the new programs with new time of use rates? I'm trying to understand how we would figure that out in a looking forward basis, because I think that's what we're trying to do.
Chair Sieben, Commissioner Tuma, I will admit that this is sort of organically coming up for the departments. I don't know that we've thought it through perfectly, and it would probably need to be in Xcel's next rate case, so I don't know how you would want to deal with the lag. But I think the way we would want to do it would be to look at customers that the utility knows has an EV, how much electricity they're using, what share of the fixed and variable costs that they're paying compared to a residential customer that does not have an electric vehicle. So I think it would be the class of customers that are charging an EV relative to the class of residential customers not charging an EV.
Yeah, that's good. I was just trying to think myself through a class cost of service study. All of a sudden I got into rate cases. I started going down a very deep vortex. I'm going to stop right there.
I will work on a decision option that tries to capture this.
Overall concern that I think is, Mr. Pollock, like I understand the alignment of wanting to match up EV owners who have, or I'm not speaking clearly either, electric vehicle owners, to put them onto the time of use rate. And that's ultimately what your proposal is doing. I don't remember in the time of use docket when we set those different rates. I seem to recall, like in my head, that there would still be electric vehicle options, charging options available for customers. And so I'm having trouble understanding why, for example, we have an electric vehicle, we're on a managed rate, I think, and I don't want to be on a time of use race for my whole home. I want to be able to charge our electric vehicle at night, and by your transition here, it seems like you're forcing my household onto a time of use rate, so tell me what I'm missing. Would electric vehicle households still be able to have managed charging rates separate from your elimination of the EVAH?
Yeah, thank you for the question, Chair Sieben. It's a good question. So what our proposal was in the TOU docket, so the analysis, because we're looking at the residential class as a whole in our analysis. So that included all residential consumption. And so what our proposal was to...
Your proposal now, I want to hear about.
Right,
you're talking about what was in the...
Yeah, and I'll just stair step to that so that you just kind of understand the backdrop. So what I follow with makes sense, I guess. So our proposal was to include, the rate design for all residential services. Mm-hmm. And so that includes the special tariffs for EVs. And so that part didn't change. We were asked, instead of approving that in that docket, we were asked to bring that to the TEP, which we did. And so that's
what this proposal is.
Yes, now. Yeah. So that's why it's stair stepped from that TOU docket to the TEP CIP docket. And so the proposal hasn't changed. It's the same change, or it's the same proposal, and it's the same math that was.
But will residential customers, like my family, still be able to charge their vehicle on a different rate in a different program, and then you have to tell me the name of that, versus transitioning to whole time of use rates for my household?
Yeah, no, I'm sorry. I probably confused you with that statement I made earlier. You still will have the ability to select whatever rate you want, rate design, so 1 period, 2 period, or 3 period for your house. And you will also be able to select a time of use rate for your EV, which you would want to do given the off-peak, lower off-peak rates.
And then
so
how many different time of use, or excuse me, electric vehicle options are there? Different programs for residential households only?
Yeah, thank you for that question too. So there are 2 main programs in the EVAH tariffs. So there is it's called pay as you go, and so that is just the TOU rates that we've proposed, with 3 different options under that. I believe one of the options is now closed. There's a bring your own charger option. There's a company charger option, and then we had a prepay version, which was basically just a version to buy a charger outright from us that we closed when we brought the bring your own forward. And so that's one option together. And then another option is the subscription service, where we take a look at EV drivers in general and provide a way to have one low rate for a whole month's worth of charging. And that also has 3 options.
Okay, well, I don't need all the options,
Okay.
but I just want the general idea, like those programs will have openings and will continue to exist regardless of what we do with EV or with rolling this into the time of use.
Correct,
proposal.
yes,
Okay, that's
Chair
helpful.
Seaman, yep. And
That's-
so you'll still have all those same options. And so, as you can see, there's a lot of complexity in those options. And so creating a special rate design for all those options that differs from the rate design that is available for all of our customers creates even more complexity.
Yeah.
So, yeah, I just wanted to share that.
No, that's helpful. Any, do we want to take a break, Commissioner Partridge, so you have time to talk to staff about that? And then, or are there other questions for parties about other parts of the docket? Commissioner Hom.
Thank you. Thank you, Chair Stephen. So once again, this is a high level. I think given that how federal credit is going with EV, I think there is a strong disincentive to adopt a new EV. Meantime, this EV market is mature, so there's a secondary market is getting bigger and bigger. What is your current proposal and possibly what we need to do to accommodate the change in circumstance?
Chair Sieben, Commissioner Hom, the company's kind of strategy and proposal as seen in the TEP is kind of, we need to support charging. Like in order for EVs to be supported in our service territory, charging needs to be established. So it's really about creating accessibility and to charging options for our customers. And that's a lot of what you're seeing in our proposal.
Yeah, thank you. Particularly that one of the decision option talking about you consider how your plan is impacting low and middle income class. Particularly, this secondary market might be popular for the low income group, and that means that their housing style might be different. It may not be a stand-alone suburban house. It might be urban multi-dwelling house. So in that case, you may have to have a different strategy to deploy those charging stations.
Chair Stephen, Commissioner Hom, agreed. And I think one of the things that, in reviewing the record, that I wanted to make clear today is there is our residential programs, and while those address some of the concerns about equitable access, it's really our commercial MDU and public charging programs that address those issues, because those give our renters and MDU families access to charging. So we do think that the rebate program that we're proposing through ECO will get to those customers and those that population that we're trying to reach, and that could take advantage of the secondary market.
Thank you. So it's not about just equity issue. What I was saying is more market-driven issue, that if secondary market is more popular, and that may be associated with that group of demographics. So I think rather than I describe that as a equity issue, it is a market-driven decision that market is getting bigger, and I think you should incent those market group to adopt EV. Then I think you have to have a certain charging station availability based on different housing style.
We agree, and I think our proposal gets to that.
Okay, thank you. Can I ask? So, departments, I think sounds like Xcel will bring this into ECO, and then I think once again I might emphasize is yes, equity is important too, but I think it's also market-driven outcome potentially. This secondary market is getting bigger and bigger, and then who is potentially using that secondary market may have a different demographics. So hopefully we can have a more focus on that based on economics.
The department agrees.
I have another issue related, I think it is related to this one, and that's the level 1 chargers. So in the department's April 6th new 32 that was filed, you have 32C, which is expand eligibility to allow for level 1 charging in the EV Accelerate at Home program. And what I wanted to raise for discussion is the idea of also looking at level 1 chargers in commercial settings. So one of the very obvious use cases would be at the airport, although personally I think you could see this being an opportunity at apartment buildings, hotels, other places where cars are parked for long periods of time. Mr. Haig is nodding. I feel like you did put something in the record on this, so credit where credit is due. And so anyway, I will say I was hesitant to say this because I feel like I'll embarrass myself, but I've had an EV for over a year now, and I've never used a level 2 charger to date. And I think that there's really an underemphasis on the opportunities for level 1 to meet a lot of people's needs. I don't drive a lot, but I drive more than many. You know, I've got 2 kids and activities all over the metro, and I've never needed a level 2 yet. Now, maybe I will eventually, but right now what I found is that level 1 has been perfectly fine to meet my needs, and it is a cheap way for me to charge at home. I did not have to make any upgrades to my home to do it. You wouldn't have to make any upgrades to a lot of different facilities. There's not as much infrastructure that you need to invest in. So I think just really considering the opportunity on level 1, which is such a low-cost, easy way to provide charging for more people. And I think it's hard to understand before you're comfortable with it, whether that's going to meet your needs. But personally, I'd say many people may find that that's all you need. And I especially think in places like the airport, when you see an electric vehicle that's been sitting there for potentially days and days on end, plugged into a level 2 charger, taking up that infrastructure, you know, it's kind of a shame to see that. So I'm wondering if, Dr. Lieb, if you would be okay on 32C, if we just modified that to add on, let me see. Sorry, my machine fell asleep here. Options for commercial customers. or in commercial settings, whatever. I'll look to staff to see what would be reasonable there, and if the other commissioners feel that would be useful. It's just an exploratory, tell us, look for options and tell us, what you find.
The department has no concern with that added.
I missed it though, Commissioner Partridge. So expand eligibility to allow level 1 charging in EVAH programs, and then you added something?
Yeah, so the initial statement is require Xcel to investigate the following in its next TEP. So it would just be an investigation and discussion, and then expand eligibility to allow for level 1 charging in EVAH programs as well as commercial programs or in commercial settings, whatever our expert order writer thinks would be the best way to word it.
Okay, I thought it was a replacement, so that's much more in line with what I was thinking, because I still want to have the
Both,
level
yeah.
1. Yep.
Yep.
Tracking now.
Before we take a break, Commissioner Partridge or Commissioner Hom, are you ready to say where you think we should head so that we might have a break to just think about what you're thinking? Or Commissioner Tuma?
I thought you purposely left me out.
Well,
I had a little too much already today.
I know what you think, but I didn't state that right.
That's okay.
Yeah, I thought I had some idea, but I think after I heard the discussion with Commissioner Partridge, if you're okay, you can make overall recommendation, or we can work with how to incorporate what you're trying to do. I think, so yes, I think that I think I need some time to think it through and connect and what to remove and what to add based on the discussion we just
Okay.
had.
And we can do that after the break, then give you both time to
Okay.
talk to staff and then come back and hear what you're thinking.
Okay.
You too, Commissioner Tuma.
I'm looking forward to see what they're thinking. So.
Will coming back at 5 to 2 be enough time, or 2?
Yeah, I think that's fine. I had,
Oh, sorry, if you had other
sorry.
questions
I just
too.
had, I think, one more issue to ask about. Sorry, I've got a lot. This is my first one of these, I'll just say. So probably the second time around, I'll have fewer questions. I keep missing it. Okay, the charging perks. So the charging perks, the model is a bill credit rather than a time of use, and you're doing managed charging. I think the OAG had some comments on this. I don't know if they're ready to answer questions. So one of the things I struggled with understanding is that the way the program is proposed, there's a $50 signing bonus, we'll call it, to say you get this if you sign up for to be actively managed. I appreciated and was swayed by the conversation about how even if we don't have data to show that it is cost effective today, that the company has said it's really important that we start to actively manage these loads, because as they increase, the marginal benefit actually goes up. And so we need to be ready to do that and build that capacity early on. So I thought that was great. I think the one thing that the OAG raised that spoke to me a little bit was this idea of where to put the different dollar amounts. I think the OAG had said maybe you want to give a higher signing bonus for those in the distribution optimization zones, and that may entice those folks that have that higher value to sign up for the program, as opposed to giving them a higher annual bill credit. And I just wanted to pose that for the OAG to speak to, and then the company to speak to, because what I will say is that the annual bill credit of $25 versus $50, I think may get lost on most people. Like $25 spread out over an entire year is about $2 a pop, $2 a bill. And it might be indistinguishable for most people who are getting their electric bill, especially with the EV load in there, that they're getting the $2 credit. And so I did feel fairly interested, I should say, in the OAG's idea that you would give that credit up front, which would be maybe more visible and attractive. So,
Ms. Hinderly, please state your name for the record.
Thank you, Chair Sieben, Commissioner Partridge. My name is Catherine Hinderly. I represent the Office of the Attorney General, Residential Utilities Division. Thanks for bringing up the issue, Commissioner Partridge. And we do appreciate Xcel bringing this program forward. It's something we recommended in their last TEP. We think it's a great idea to move forward. And so our recommendations here are really just seeking to make the program as cost effective as possible. Understanding it's not going to be cost effective right away. You know, there will be a few ways, and you can make things more cost effective by both increasing the benefits or reducing the costs. And so one way to increase the benefits is to really, kind of induce as much as possible the optimized, the distribution optimized participants, or DISCO vehicles, I think is what Xcel calls them, which is kind of fun. So our idea to do that was targeting customers in areas that are likely to qualify for DISCO, but also providing them with a bigger sign-up credit. Our thinking was just kind of from a common sense perspective, as Commissioner Partridge noted, once folks are signed up, they're likely to remain signed up after taking that hurdle. And so giving them a higher annual charge is probably not going to do much to really change program participation. Xcel emphasized that the customers will have essentially the same charging experience, whether they're distribution optimized or on the standard or considered a standard vehicle. So essentially, I think we're just kind of giving folks an extra $25 a year, which doesn't sound like much, but over the course of time will add up and drag down the cost effectiveness of the program. And we just thought, it would be better just to give people the money up front to try to get them to sign up for the active managed charging program if they're in these areas. Xcel raised some concerns regarding messaging and wanting to make sure people were confused, and we certainly take that seriously. We think there's also probably opportunities for customer confusion if they are getting a different rate annually, just not knowing why, if they got a higher rate one year and then it turned out, for whatever reason, a feeder was upgraded and so they don't qualify for that distribution optimized area anymore. So this is what made sense to us. I think that's our recommendation, and, happy to discuss further.
Thank you, Chair Sieben. So, yeah, I do not necessarily disagree with you, but I think we have to think more in the long term. So I think the key is retention rates. I think you said, as of today, retention rate is high enough. So even though we give them upfront incentive, they still stay. But we have a Federal Energy Regulatory Commission Order 2222, which allow third-party aggregator, and potentially there'll be a competition. So have you factored that into your understanding of a historical retention rate versus a future retention rates?
Chair Sieben, Commissioner Hom, so I want to make sure I'm understanding your question. I understand your question to be, have we, assumed that commercial aggregators come in and can market to customers and are competing with Xcel, that might change the analysis? I think there's a lot of unknowns in that scenario. I do think that status quo bias, which is the term that Dr. Sharber told me to say, but she can correct me if she wants, is very real. And, if customers are signing up for this and signing up for in the future, Xcel does have, they are the utility. They're who I thought to go to first when I bought an EV. Like, they're going to be who customers think to go to first. And I think this will be an attractive program. Like, in its current, unlike maybe what a commercial aggregator would require, in its current form, Xcel is allowing people to override the managed charging. And I can't imagine a commercial aggregator doing that, because then they wouldn't be able to fulfill their obligations that they've made to MISO for bringing down the demand, right? So currently, customers can override if they need to. We want to track that and make sure it's not being, abused. But currently, that's, I think, a big leg up that this program might have on a commercial aggregation, just thinking about it today.
Okay, thank you. Yeah, I'm not saying one way or another, but I think when we are discussing this issue, that just using historical data may mislead us to it. And but I think at least Mid-Continent Independent System Operator told the FERC that they will comply by 2028 on how to carry that out in their market system. So potentially as early as 2028, we may have to deal with this issue. So since this is a 2026, so that's why I think we have to give a little more thought in overall discussion on this issue with the data potential, how to predict the future outcome based on the historical data, which will have a significant structural change.
Thank you, Chair Stephen, Commissioner Hom. I think all that makes sense, and I think it really goes in my mind to a good reason to have this be a pilot, which is what Xcel has agreed to. So we're currently recommending a 5-year pilot, so it would be revisited in the 2031 IDP. We think that would provide good data, and it might, if other programs and competitors have taken off by that point, it doesn't look like this is a really good space for the utility to be in anymore. That's, that might change the reevaluation at that point.
That's a good point, though, that, what got me concerned was the override, but what made me not worry so much about it is that this is a pilot, and now we're going to learn from those overrides. I think a generous override in a pilot makes sense, but if this is a permanent program, I would be less likely to want to have a generous override. So.
Yeah.
You go first.
Okay. I have a couple different staff people to check in with, so at least 15 for me.
We come back at 2:10. Does that work?
Yeah, can we, since we can't speak outside of this, Commissioner Hom, I think that my decision options will just focus on that TOU rate transition. Do you think that I could plug that into an overarching motion?
Hopefully, yeah, that I need to talk with you.
Okay, then we've got a plan.
Sounds good. The commission is in recess until 2:10.
I like having a plan.
Thank you.
got my mic on. We're back in from recess. Chair Seaman had to take off real quick for family matters, so you're stuck with me. You guys took too long, so I'm sorry about that. But I think we're going to get a path forward. So I think I want to just start there. Commissioner Hom, or do you want to start with Commissioner Partridge? Commissioner Partridge.
Thank you, Chair Tuma. I have a modified Partridge number 20 to share that would, I hope, at least be a starting point in our discussion around the time of use rates and how those could be treated going forward to better understand and accommodate the characteristics of EV customers and EV loads.
So modified 20, and that's okay. That's a full one. That's a full thing on the screen right now.
Yeah.
Let's just take a minute to read it. Dyslexic has read it, so that means that more than likely everybody else has. So why don't you walk us through it now that we've had a chance to read?
Sure. Thank you. So the idea here is that this decision option would not specify where the company would need to file new proposed rates, but it would just give it a deadline by or before the next TEP comes in. It would use existing data, which I believe the company has quite a bit of existing data from the various EV programs that you are currently running and have run in the past. And it includes the concept that you could be on an electric vehicle rate and also potentially a managed charging program as well. And in doing so, you'd want to make sure that whatever your off-peak period is long enough to accommodate a managed charging option. It does not specify the time periods, so if the company found it was more or less appropriate to have something other than a 3-period option for those customers, it could accommodate that flexibility. And the last one is that, and again, these just takes into consideration these ideas, that it could be an off-peak period that allows EV customers potentially using a level 1 charger to use the rate as well. So it's kind of folding in some of the conversation we've had broadly into the considerations that would go into the filing, but hopefully leaving enough flexibility that the company can come forward with a proposed plan or proposed time of use structure, and then we could have parties weigh in, the department weigh in, the OAG, and we can take a look at it.
So a couple of real quick questions, if I've been tracking correctly then. We would go ahead with the other pilot projects, the charge, whatever thing but this would just be those existing customers on the existing program. We're going to hold off on making adjustments to them until this filing happens. And so what's the timing of that? I see it says the plan, but when is that, like in a month or 6 months, or how long are we looking at that sitting out there?
So the idea is that we would make no change to the rates until the filing comes in. The last final due date for it would be with the next plan, and that is I'm looking to staff, that would be
November 1st, 2027.
2027.
November 1st of 2027.
Right. But if the company can bring forward a modified proposal in the current docket, they could do so ahead of that date.
Okay, yeah, because it does say no later than.
Yeah.
So we could go a quicker approach, and that was going to be kind of my next line of questioning is how would that look? And I guess it would be the company and the parties here
Right.
coming together on a proposal and then bringing it to us before the next
Right.
step. And so it would be in this docket then and not in the next step.
Yeah. Yeah. So it doesn't specify the particular docket. It just kind of sets a deadline. But if the company was able to do a cost of service study to look at, EV customers specifically and bring it forward within the next year, that'd be great. But I don't know what the timeline would look like for them.
Commissioner Hom, do you have any clarifying questions before I throw it to the parties?
Well, I have a question to parties, so I think I can wait.
Okay,
Until-
I don't have any more clarifying questions, so if you don't have any clarifying questions, ask your questions, Commissioner Hom.
Yeah, only one question is, company, do you need anything else to be changed if we adopt this proposed modified 20? For example, current rate case or the approved existing time of use rate, do we have to change any of those? Or can you automatically adjust that rates without modifying those tariff?
Chair Tuma, Commissioner Hom. Based on what's been proposed, our expectation would be that nothing changes until the proposal is made and the commission has seen it. So nothing would change in the interim.
Thank you.
Do any other parties want to comment on number 20? You are free to come forward now. Doesn't look like anybody's rushing forward.
Does the department support this? Okay, I'm getting an affirmative nod for the record.
I saw an affirmative nod. Sign language is this.
Okay.
No, this is yes. Yes, there you go.
Okay.
Okay, then I guess we're on to Commissioner Hom.
Thank you, Chair Tuma. So, Commissioner Partridge, you discussed decision option 11. So, do you still want to consider that, or?
Hold on, I'm finding it. Oh, yeah, I don't. I hope that there's really robust conversation in the next report about this. And I haven't seen your full motion, but depending on what way you go, I do think an evaluation would be very helpful to understand, if this structure you've proposed is really incentivizing customers to sign up, particularly in those really high value areas. So I think it was a really great discussion by the OAG. I would, I'm not an expert in program design. That kind of makes sense to me, but I think for the purpose of moving forward, and I know that Commissioner Hom knows a lot more about how the FERC context is changing. And so in that respect, I just think a really good discussion so that we can keep monitoring that, which I know the company also wants to do, because you do want, I'm sure, to really maximize the customers in those high value areas. So I'm fine moving forward. I did have that one addition to the department's 32. And I think...
Yeah, I can make a motion, and if you would like to modify it, or you can modify it now as your motion, then I can consider it.
Okay. Yeah, whichever order. So if you are open to the new Department 32, which is just setting up things to discuss and explore in the next plan, I modified C that would add level 1 charging opportunities in multifamily and commercial settings is all.
You said as well as.
Yes.
As well as.
Yep. So it'd be level 1 charging in the residential setting as well as multifamily settings and commercial settings. Those were the only items I wanted to throw in.
Waiting for you, Commissioner Hom.
Thank you, Chair Tuma. Then I can try to make a motion, and then we can discuss any additional, or if you want, you can hear from the parties. So I'll make a motion to move decision option 3, 5, 6, all A, B, C, D, 8, and 9, 14 from 8 through R.
Including R or?
Yeah, including R. And then I can ask company why company was opposing it, but to me, it's just reporting requirements. So I'll just initially move as it is.
R, so okay,
Yeah.
good. Yep.
15, 16, 17, modify the 20, 28 as it is in the language, but I already explained that this is a more of economic driver. So I think hopefully Xcel can use this economic driver to achieve the same thing. So but I'll move the language as it is. And then modified by Commissioner Partridge on Department New 32, all of it.
Okay. That looks good to me. Commissioner Partridge, any suggestions, changes?
I think we got it because 32 pulls in some of the other pieces. So yes, I just had to remind myself.
Applicant or any of the parties?
Oh, staff has.
I have a clarification.
Oh, sorry, Christine.
No, you're fine. I just want to clarify decision option 6 and decision option 9 sort of juxtapose each other, so I wanted to make sure that's clear. Decision option 6 has the 5-year term. Decision option 9 has a hard cost cap.
I think number 9 is not a hard cap, but is it hard cap? It doesn't say hard cap, it's just cap. So always company has a right to claim above and beyond with their proof of prudence.
We could put soft cap language in there.
Yeah, if company is more comfortable, that was one of the things I was going to ask a company about language in 9, because in the chart, company says that they are neutral. And then 14R, why company was opposing that compliance filing in the 14R.
Wait a minute.
Chair Tuma, Commissioner Hom, on 9, we were neutral because we were looking for some soft cap language. So if we could add that, that would be great. And then on, do you want to, anything else on that one before I move to 14?
14R.
14R.
Based on what I saw in the staff developed the chart, company oppose 14R. And what is the rationale? And do you really oppose it or you don't like it?
Chair Tuma, Commissioner Hom. The opposition is based on the fact, so we could do percent charging during on-peak sessions, obviously, but determining a cause for override is really where that comes from. We're not going to know why the override happened. So there would be a number. We could make inferences. We can do that, but we just wanted to be clear that knowing why the override was being requested is something that might not be within our control.
Yeah, understanding of potential confounding cause can dilute the value of the data, but company can still pick up collect the data and then report.
We can do that, yes.
All right, thank you.
So staff brought to my attention that if we want to do the soft cap, that number 10 might accomplish that instead of 9. unless Excel shows. Does that?
Yep, that's the language I was just actually trying to remember where it was, and it was right there in front of my face.
Same. I did not remember that.
I thought I saw it.
Okay. The company is okay with the number 10, so I'll withdraw now my decision option 9 and add the decision option 10.
Okay. Any other concerns from the applicant?
Chair Tuma, Commissioner Hom, on 28, just scrolling to it. I think it would be helpful to understand and or potentially modify it. You're saying, based on our previous conversation, you're thinking that there are economic drivers that would drive investment towards more charging in for these residents. I'm not sure I understand how specific enrollment targets aligns with economic drivers, and so if you could speak more to that, that would help us.
First of all, as I discussed last week, I know that you guys need to comply with the federal requirements. So that's why use a language that is appropriate to comply with federal requirements. Being said, I think economic driver and our state-driven equity requirement is aligned. So that's why I think you can use a language you are comfortable to comply, but still you need to give us some number target that you can do it based on economics.
Would that be an enrollment target or investment target?
Enrollment target is unlimited cap, so investment target might be better, but I think also it has to be combined both. I don't want company to spend a lot of money with very low enrollment, but also I don't want company to meet the target enrollment, spend a lot of money either. So you have to balance it.
Can I ask a quick question? I should have asked this earlier. Sorry, Ms. Steinhauser. I know you're trying to juggle and chew gum and whatever else right now, but
Juggle on a use cycle.
I think one of the questions that I had that I should have asked this earlier is when we talk about these programs, we're not seeing high uptake in low-income communities where we'd hope to see higher uptake. Do you have data to show that there are electric vehicles in those communities and that the barrier are the programs, the charging programs? Or are we really dealing with the problem that these communities, folks that are living in these communities, cannot access the vehicles because they are themselves expensive? Do you know the answer to that question?
Chair Tuma, Commissioner Partridge, that would be a question for Mr. Roach.
Okay.
Welcome back. You don't have to state your name. We know who you are.
Could you repeat the question, please?
Sure, and I'll try to be articulate. I think one of the issues that sort of flows into number 28 I should have asked about earlier, which is it was, early in briefing papers, many parties talked about how we're not seeing very high uptake of these charging programs and opportunities in low-income communities. And a question that I had is whether that is because there's a lack of electric vehicles within those communities, which might tell us that the vehicles themselves are inaccessible to folks who are living in lower income communities, or if you have data to show that in fact there are vehicles within those communities that could be taking advantage and benefiting from the programs, but the barrier is actually to the programs themselves.
Thank you for the question. I think we do have some high-level data, and I can't speak to the distribution of EVs right now, but we do have access to registration data by zip code, so we could analyze that, but we don't have that analysis done today. I do think that we have identified barriers in our program design, specifically things like charger rentals and EVA that, it requires a 10-year agreement, which is not really conducive to rental or multifamily.
Sure.
And then throughout the proceeding, we talked about the barriers of our previous EV pilots around multifamily. That was one of the big findings, and one of the reasons that we've shifted to a rebate model, both at the residential level and at the multifamily, which we're bringing forward in our eco plan. So I would say that we've made adjustments to the program design aimed at targeting those customers, and those programs targeted at those customers are primarily rebates brought forward in our eco program, both at the MDU level and at the home wiring rebate for residential customers. Those are either not approved yet or very early stage, so it's tough to say what the impact of those program changes are at this time.
Okay. So to Commissioner Ham's decision option, you should, if you're filing them in eco, you should have some targets for those programs then already?
Yes, correct. We do have targets in
Okay.
our filings.
So there you go.
Thank you. Yeah, I think I do not have much knowledge of the eco, but I think that you work with the department, so hopefully you guys can work it out. But my discussion was we shouldn't spend a lot of money to meet the targets. I think that's why eco is a good place to discuss. That place is discussing optimum deployments. So let's leave the target at that place.
Chair Tuma, Commissioner Hom, that makes sense, and I've received intel from the team that they're comfortable with that, so we're good. Thanks.
Okay. I think we're ready, unless anybody else has something to say. Doesn't look like anybody's rushing to the table. So we have Commissioner Ham's motion. I'm looking to Ms. Fazo. You are good. I'm good.
I just want to thank Commissioner Hom for putting together this complicated motion when I skirted the responsibility to do so because it was too
Yes, you were
messy.
offered a chance to do this, weren't you? I forgot.
Yes. So thank you, Commissioner Hom. Truly, thank you.
Oh, good. All those in favor of the motion signify by saying aye.
Aye.
All those opposed, same sign. Motion passes unanimously. We are done. No more business on the agenda.